And boom. So today we've got a really fun case, really actually exciting case, because this one's got the potential to stir up everything. And it started in Maryland. I'm hoping it's going to spread, across the U.S. and hopefully Canada. But I don't actually know how the last name is pronounced. Abrukwa or Abrukwa?
I've been saying Aberqua, but I could be wrong.
Yeah, so it's Abrukwa versus the state of Maryland, and this is a case about firearm ballistic, specifically ballistic matching, where they're matching one bullet to another bullet and saying these were fired from the same gun. This is a big deal because there's so many cases where this is sort of the basis for a conviction. They say we found this guy with a gun, we matched it to a bullet that's found in this dead guy, therefore case closed, all wrapped up, which sounds great if it works. And that's where we're getting into some trouble here. So I think people here know me. I'm a Canadian criminal defense lawyer and I do firearm law as well, but I'll let each of you introduce yourselves.
Natalie?
Oh, thank you. So, hello, everybody. My name is Natalie. I am a criminal defense attorney slash public defender out of Prince George's County, Maryland, which is where this decision is from. I'm here on YouTube under the name Natalie Lawyer Chick. It's nice to see all of you.
And I'm Steve Gosney. I'm an assistant public defender in the 7th Circuit of Florida. I do criminal appeals, including death penalty appeals, Daytona Beach, Florida, for the 5th Circuit or the 5th District Court of Appeal. And I'm a strong advocate for exactly what this case is doing. And I'm trying to bring it here to Florida, Supreme Court of Maryland. And I salute Natalie's bar. This has obviously been set up by a lot of hard defense work, and your Supreme Court got it right. And I hope that every state in the union follows Maryland on this particular issue, because I've been a very vocal critic of this tool mark matching stuff. So it's what we're talking about is, bullets being matched to particular firearms to the exclusion of all other firearms in the world, or shell casings being matched to a particular firearm to the exclusion of every firearm in the world, which is junk science, and it's going to has led to false convictions. That's why, obviously as defense attorneys, and, prosecutors should also be concerned about false convictions, but unfortunately, too often they are not. So it's incumbent upon us to really advocate to get rid of this kind of junk science out of the courtroom. And, there is a wide swath of ballistic evidence that can be introduced that this allows, but it's that specific testimony that the bullet found in the head of the victim fired from this particular firearm. That is not, they can't do that. And it's junk science. And this case does a great job of explaining it.
Yeah. So for the people in the audience who are sort of wondering what this kind of analysis is basically the idea is that a tool, like any sort of, and a tool is any object, really. When it impacts another object, the idea is that it's going to leave marks, and that those marks might be more or less distinctive. So I've got, this thing I think makes an excellent prop for this. You can see it's got sort of jagged edges on each of these little obsidian bits. So if you imagine that you scrape this, I don't know, through some cheese or something, along those lines, it would leave a particular pattern. The idea is that like metal on metal does the same thing, metal on wood does the same thing, all of that. But then they say that we can identify this down to a certainty. And the problem with that is that we really don't know that, because we don't know that there's not two things exactly like this, especially if we're starting to talk about things that are themselves produced. Like this is a handmade piece item. It's probably a lot more unique than most things we own. My pen was mass produced. Like this came off a factory. Every gun I own came out of a factory. And so it's just the product of a factory analysis.
And this tool mark evidence is quite widespread. And the problem is there are no databases of these things, and the underlying premises by which the assumptions, but the assumptions that are made in order to come to a conclusion are false assumptions. They are not provable assumptions. So, and that's the problem. And what happens is there's an institutional inertia that grows from experts who have a little organization, and they get around in conferences and they talk about how right they are, and there's confirmation bias. Oh, everybody that I've testified against has been convicted, so they're guilty, therefore I was right, when in fact they may be convicting innocent people. And it's a real problem. And so this analysis is so, I don't have a familiarity with the Supreme Court of Maryland. Natalie does. I'd like to hear her impression of her Supreme Court, because obviously these people, this opinion is so well thought out, and they put some real brain power into it. It's a opinion worthwhile reading front to back.
So yeah, I'll give you guys impressions of the Supreme Court of Maryland, but a lot of this opinion is grafted from the hard work of the Public Defender's Office of the state of Maryland. Maryland is one of the minority of states that has a centralized public defender's office, that has the organization that is able to mobilize against this type of what I think is junk science, right? So we have a forensics department that we consult with in our cases, and they will pick up on an issue, ballistics, the breaking down of DNA after it's been put through the washing machine, and you get a piece of clothing out and they're saying this is someone's DNA on this piece of clothing, but they're not talking about, transference, for example. There's all these hot button issues that the Maryland Public Defender's Office has very dedicated forensic attorneys who are on it, and they will consult with us all across the state, get us experts all across the state. And since the PCAST study, the ballistics evidence has been one of the things that we have been championing for the courts to take another look at. And I'm so glad that the Supreme Court of Maryland was willing to be open-minded enough to set aside, like what Steve said, the biases, the confirmation bias that a lot of people have about ballistics evidence.
Well, and Natalie's jumped over it, but she's talking about PCAST. I have PCAST right here on my desk, and I'm a big fan of PCAST. I've been championing this point for quite a while, and I always go back to the PCAST. And that PCAST is it's a report to the president, forensic science in criminal courts, ensuring scientific validity of feature comparison methods. So this is President's Council of Advisors on Science and Technology. It's kind of the gold standard, the blue ribbon. And this calls into question a lot of this tool mark matching evidence. Not that you can't, we aren't saying that you can't bring it in. You can't do analysis of firearms. We're saying that you can't do the kind of matching that they're promising to do in a lot of these court cases. And it's dangerous because it has the risk of convicting the innocent. And I also point out that Natalie makes a very good point too, is that this case, when you read it, screams of a lot of hard work at the trial level. Yeah. Was this a public defender case to begin with?
Yes.
Okay, and salute to the public defender's office. I'm a public defender. I guess Natalie is also. And it's great. This is what you call a great service. Your public defenders are working hard to prevent the innocent from being convicted by junk science. And it's very much reflected. They did a great job at the trial level all the way up.
I know we want to get to the decision itself, Ian. I'm really sorry, but I just really want to say what is so concerning about the way in which Maryland was allowing ballistics firearms examiner evidence to be introduced. It was previously a match. They were able to say this thing matches this thing. Here's what the problem is with that. Ian already alluded to it. There's two types of tool marks that are impressed upon a projectile, be that the bullet, the shell casing, a fragment, whatever the case may be. And that are the class characteristics that come from the manufacturer, like the ejector tool. It could be ellipses shape or square shape or whatever the case may be. That's always going to be the same because, like Ian says, it comes off of a conveyor belt. And then you have these individual characteristics, basically accidental individual characteristics that are imprinted upon these projectiles. And so they have to have a certain amount of class characteristics. They basically have to all agree in order for you to say that, okay, this came from a Glock, for example, right? Okay, this came from a Glock, but which particular Glock? Now you have to have the individual characteristics match, but there's no standard for the individual characteristics. Absolutely none. It's sufficient agreement amongst individual characteristics, which to me is ridiculous if you're going to say that it's an exact match. Sure, you might be able to say it's consistent, but one tool mark could have 3 individual characteristics that are consistent. Another projectile could have 4 individual characteristics that are consistent, and they'll still call them a match because there's no industry standard for how many of these individual characteristics have to agree with one another. And that is a major problem in this entire, study, if you want to call it that. It's not
Right.
science, but a study.
People were asking about individual techniques, and there are, like, another one is shoe print analysis. So using a shoe print example, if
Great.
you could say, okay, this was created by a size 9 Nike, I don't know, Air Jordan, right? Okay, and that's fair enough. And we found a size 9 Nike Air Jordan in the defendant's closet. All right, well, that's pretty good. And so this shoe print is consistent with the shoe found in the defendant's closet. All right, that is all well and good. Same thing here. The bullet recovered is consistent with being fired from the .38 caliber revolver found in the defendant's possession. All right, all that's fair and good. What problems become is when you say it's this shoe to the exclusion of all other Nike Air Jordan 9.
Yeah.
To all the, now it may be, and I fast in the chat it asks this, it may be that there's a specific like cut or wear mark on the bottom of the shoe that distinguishes that from all other shoes. Okay, maybe. But in the area of mass manufacturing, they're saying that they can distinguish individual striations of a mass manufactured rifled barrel to the exclusion of all other rifled barrels produced by Glock. See, that's an impossibility, and it's also not falsifiable, which is required for science. So when you have this kind of matching evidence in a trial situation, I'm a defense attorney, and here's this finger of accusation saying my gun fired that bullet. That's very damning evidence. But how do I defend against that? Well, I could say, well, I could access a similar matching barrel, but there is no such database. There is no way for me to falsify that. So it becomes impossible to overcome it. So that's why it's so important that it gets excluded from presentation to juries. And that's what this court is doing.
Absolutely.
And you can't underestimate the mystique that this has to a jury. They see this guy who, and they're like, oh, this is some independent guy who is usually as independent as he works at the police office and considers himself a cop, so not super independent at the end of the day, but they'll feel like this guy's independent because he's going to show up, he's going to say, he's going to be wearing a suit, he's going to be and he'll say, oh yeah, no, I did all this science, but the science is often just, I looked at some things and I feel that this is the same.
Absolutely.
Go ahead.
Oh, I'm sorry. I misspoke. I wanted to correct something that I said. So the public defender has the case at the appellate level. But at the trial level, the attorneys were Stanley Reed and Bradford McCullough. So Stanley Reed and Bradford McCullough, who argued this motion to Judge Pearson, and they did a great job in their arguments. It was all the talk of the courthouse.
And this is your office, right?
No, those two attorneys are private attorneys. So I wanted to give them their credit. We just had it at the appellate level, but they laid all the groundwork at the trial level to preserve the issue. And it was a multi-day hearing with Judge Pearson. I quibble a bit with our Supreme Court. Instead of saying, look, the issue was the science, they said that the issue was Judge Pearson abusing his discretion. I didn't think that was fair because...
Well, but it's actually much better as an appellate attorney. It's much better that they use the abuse of discretion standard because that makes it much more powerful to argue as a trial attorney to your judge. It's not a de novo review based on the evidence below. It is that this is an abuse of discretion to allow in this type of non-scientific testimony due to its volatile and dangerous nature. So I understand that if you have a relationship with the trial judge, and all due respect to that, but it's as an opinion, as a useful opinion, I think it's much more useful for the world who's looking to Maryland that it was found. It was found as an abuse of discretion to allow in this kind of testimony.
Yeah. So no, go ahead.
No, I like it. Cheers to you guys. My wife brought me some goodies here.
Oh, that's nice. So the thing is this, as a trial level attorney, it's always nice to say to different judge, hey, it was abuse of discretion, give me what I'm asking for. But I am just saying that the way that the law was at the time, and we had just recently come under Roshkind, which was the is the Daubert standard. Previously, we were under Fry-Reed. So we had just changed our standard and everything like that. I didn't think it was necessarily fair to the judge to say it was an abuse of discretion, but it's great for us defense attorneys. Do not get me wrong. I just, I know that he put a lot of thought into that decision. I didn't agree with it. I still don't agree with it now.
In fact, the dissents were focused mainly on the abuse of discretion standard, as well as the, they kind of look behind the curtain a little bit. And they think, well, this guy did it. And we were talking a little bit about how courts just hate letting anybody away that's guilty. It's like, that's the worst thing. We can't allow that. And so they move the law in order to convict somebody that they think is guilty, which is not the way. We shouldn't, there's some cases that are almost guilty, that are halfway guilty, right? Or almost solved cases. Not everything is beyond a reasonable doubt. It's not black or white, and we deal with those vagaries at the trial level a lot, right?
This is actually an interesting distinction between Canada and the U.S. with regards to evidence from searches, because in the U.S., if it's a bad search, the evidence is out, right? Full stop, no matter what. In Canada, there's actually a second step of should we allow the evidence in?
That's not quite true, but it's nice that you think that. It's very quaint.
Well, it's the idea, right? But
the idea, yes.
In Canada, we actually have a second step where they can say this violates the rights, but we're going to let the evidence in, and we're going to take the evidence out. They have to actually ask that second question. And when I look at the difference between like Canadian and U.S. case law, when you get to these hard cases where it's like, somebody has killed 3 women and, they went into the guy's house and they found the bodies in his basement. And it's like, we're really clear this is the guy, but it was a bad search. In Canada, the way they do that is they'd say, okay, it was a bad search, but it may not have been that bad. It depends on the circumstances. And they might say, this violates rights, but in this case, we're going to let the evidence in.
It's interesting to see, and really, one of the jokes that everybody makes is Gosney had written an article on it, right? And I will say, in my book, Ideas and Answers in Law, I talk about the good faith exception to the warrant requirement, and that is, and Natalie's a trial chick, right? So you know what it's about. It's like the judges think, well, Mr. Cop, would you testify? It's like, were you operating in good faith? And the guy says, why, yes, I was. And they say, well, there you go. And they let it in, even though it's in violation of rights. But that is a misinterpretation of the exclusionary rule. That is not the way the good faith exception should work. And there is a case called Herring out of the U.S. Supreme Court. And in Ideas and Answers in Law, I propose a test that is based on proximity, that's objective. But as part of that test, I also propose that there be a balancing of interest in the ticking time bomb case. And just like what you're proposing in Canada, that you say has in Canada, which I'm not familiar with, but yes, there has to be room for the extreme examples. Even as a defense attorney, we have to recognize that police have a job to do too. So there is a balancing there that has to be occurred. But Herring versus, Herring is the case right now. And the basis for the exclusionary rule under Herring is that it must serve some deterrent effect on the agency. And that is the sole basis for exclusion. And Herring, in fact, involved like a cop in Georgia who was relying on a stale warrant out of Florida and had no way to know, and was a different agency. So there was a lot of distance between the warrants, the illegal warrantless search or the warrant search, and the actual agency that was being deterred. So taking that in flip, I'm proposing in ideas and answers that proximity, if it's close in proximity, then it should be much more likely to be suppressed because the prophylactic effect would be much greater on that agency, flipping on the other side.
Kind of like reverse attenuation or something like that.
Right. There you go.
Yeah.
Yeah.
Well, what I've seen in the States and some of the decisions is because it's such a bad case, they find that a right doesn't exist. And so they'll say like, oh, they're just searching your car. That's not such a big deal. And then the problem is that for everyone else, it means that right has then been diminished. Whereas the other thing we'll see in the Canadian jurisprudence is they'll say like, oh, the officer, like, we'd never litigated this before. We didn't realize that this was a thing that was an issue, like with cell phone searches and that kind of thing. And then they'll say, we're letting the evidence in. It's a violation. And now you ought to know. We're not going to let the evidence in next time, guys. Like, you're on notice.
Well, they say that, and it never, the axe never falls, right?
Yeah, sometimes it does, sometimes it doesn't. It's
absolutely. It's so I'm correcting myself again. I said did I say we changed to Daubert? I don't know. I misspoke. We changed to Fry-Reed. I don't know why I said that. We changed to the Fry-Reed standard, which is a lot more taxing on the expert, and the judge still found that the expert should be allowed to testify that it's a match versus it's consistent with. And so that's, one of the reasons that they overturned him.
Wait a second. I think I thought you guys were Daubert because.
What did I say? So we had this case called Roshkind. Let's see here.
Yeah, this applies Daubert.
So following
because it looks like you used to be a Fry standard. Now they've changed to Daubert Roshkind.
Okay, so I was right the first time. Okay, goodness gracious.
Yeah.
Oh,
Look
thank you.
Section 2, Daubert Roshkind hearing.
Thank you.
You've changed from Fry. Fry is the old standard for writing in expert testimony.
Right.
I think I changed in Florida too. So
I read something that made me second guess myself, and I was like, "Oh no, I misspoke." But no, I was right the first time. Okay,
right the first time.
Okay, I should have stayed with what I knew. Okay.
Yeah, Fry is the old standard. Daubert is actually, I like Daubert better.
It's great.
It seems more comprehensive, and you've got something interesting here. And I was reading it, and I like what you're doing here in Maryland. I'm envious of this Maryland court, I should say, because we don't get these kind of opinions that often. But they actually apply this 10-factor test, and Daubert is a 5-factor test, and they add these federal additions, which I'm quite intrigued by. I'm going to have to do the research on it.
Yeah,
because they apply an extra 5 standard. Are you familiar with this at all? Because let me see. I'll pull it up. I'll find it. Hold on.
I mean,
sorry,
this is a 128 page.
Yeah.
Well, this is a 128 page decision. So, and that's including the dissent, but it's really.
Well, do you want to dig
a lot of detail?
Are there anything in particular that you want to dig into with the decision itself?
I guess let's start with just going through the factual background so people know what this case is.
Okay, here it is. Can I just jump in real quick?
Absolutely.
Yeah, it's so it's got the 10 factors. Look on 1 under discussion, number 1, admissibility of expert testimony.
I'm there.
Yeah, you see it's got the first 5 factors are all Daubert factors. You're on factual, and then if you look on there, then there's 6, 7, 8, 9, and 10, which looks like Federal Rules of Evidence 702 committee note cleaned up for factors 6 through 10. So they call those Daubert Roshkind factors, which are fascinating. That's a really interesting
so
addition.
My understanding, which is trial level understanding, so take that for what it's worth. Our Maryland Roshkind case is more taxing, requires more of the expert than even Daubert requires, on a national level or in states that apply Daubert, because we are incorporating those additional factors. That was my understanding from applying that.
But people don't know. I mean, our trial division, they're hard work. See, appellate lawyers, we just sit around and nerd out on all these appellate decisions. Trial lawyers, they have to work every day for like hundreds of clients that are in their dock. So so they don't sometimes have the pleasure of diving deep in these things. So that's why the trial team who did this obviously did a great job, and the appellate division of the public defender's office need to be saluted. But our hardworking trial division, we have a great trial division here in the Seventh Circuit, and they can't get enough kudos as far as I'm concerned.
Yeah.
I feel like there's a lot of people who give grief to public defenders and don't give them enough regard, and that I think this case really shows that that's the wrong approach, right? Public defenders work hard, and in a lot of offices, like in a lot of areas, public defenders are have more trial experience or more appellate experience than a lot of other lawyers, and may actually have access to resources that those lawyers don't have.
Well, the access to resources is a big part of, why I love my job. So I've been a public defender. I've been an attorney for 13 years, but I've been a public defender for 10. And I had a break there in between where I said, I'm going to go do something different. And I came right back because there's a level of support there that we have in our offices that you're just not going to find anywhere else. And sometimes, so I handle felony murder cases. That's most of my docket, right? And sometimes, I say to my client, look, we're going to need this expert. And they're like, I want a paid attorney. I'm like, look, I don't want to tell you what to do. It's your choice. But are you going to be able to afford this DNA expert that we're going to need to challenge your DNA? Are you going to be able to afford to enhance this video? That's going to be thousands of dollars. You're going to have to pay your attorney and pay for this expert. So I hope that you understand that, are you going to get a mitigation specialist? I have one on staff. Are you sure about that? So it's like, I don't want my client to ever feel like they can't pick the attorney that they want, but I always want them to know, look, man, we have so many resources that just you likely sitting here in jail will not have,
Right. Yeah, no, that's well said. And I'll say that we have great support from our elected official, and when we need the resources, we need to pull out the stops. They pull out the stops, and it's great having that so that you can focus on your cases and not chasing after clients, chasing after billing, dealing with billboards or any of that stuff. It's like you are 100% focused for your case and your clients. And you also have a reputation with the judge and the prosecutors that is very valuable coin. So that and like you say, also the trial experience that you get in a public defender's office is second to none. A lot of private counsel, they're losing money when they try a case.
That's right.
We try cases all the time.
Well, the other thing is institutional knowledge. It's there's just so many cases run by the public defenders, and there's so many people there where you can quite literally walk down the hall and be like, hey, you do a ton of these cases. Let's talk. Or you were actually counsel on this critical case.
Right.
Can I pick your brain about that?
You know what it's like, Ian? It's like being in academia versus the private sector. The public defender is like a university almost. You know what I'm saying? Like, that's what it's like. We've got attorneys there that are like, our professors. They've been doing this for 30 years. You have more mid-level people like me. And then we're all, our district court, people that are doing our misdemeanor cases, they are coming to us for resources, and we're going up for resources. And it's just an umbrella, and it's great, so yes, we have a lot of cases. That's the biggest drawback. So obviously that's always an issue, is the caseload. But when it comes to experience, second to none. Yeah.
So in this case, we've got, so it's a bit of an unusual sort of set of facts. We've got police are getting calls about the disturbance that the accused is sharing with his roommate, who later turns out to be the deceased. And on the third of these occasions, just before midnight, two officers arrived at the house. Mr. Abrica appeared to be agitated, very aggressive, and uncooperative, and that the Mr. Aguirre Herrera appeared to be terrified of him. And so the police just said, stay away from each other. The police did a bang-up job here, right? Everybody to their corners.
Just stay away. They're good. They solved the problem.
Yeah.
So
good old
they leave at
PGPD.
12:15 a.m. and sometime between 11:30 p.m. and 12:30 a.m. they hear multiple gunshots. So we're gonna guess that it's like pretty much right after the cops leave. Cops leave and then bang. So when everybody says like, "Hey, just call the cops," the cops will show up. They'll say, "Everybody to their corners." They'll leave, and then you get shot to death. So 4 days later, they find his body decomposing. They found that he'd been shot 5 times, including once in the back of the head, which that's a bad fact for sentencing. Because that suggests like, hey, they had a fight, but then he really wanted to make sure.
Double
And
tap.
Yep. 4 bullets and 2 bullet fragments from the crime scene. So those 2 bullet fragments, I'm guessing it's 1 bullet split into 2 parts if they've got 5 gunshots. He's got 2 guns, both hidden in the ceiling of the basement of the residence. They find both guns, a Glock pistol, and a Taurus 38 Special. A jailhouse informant. Can we talk about jailhouse informants?
Yes, always.
So jailhouse informants are usually sketchy as hell.
Yeah.
Because, some of these guys have been jailhouse informants like 15, 16 times. I don't know if that's the case with this guy.
Listen, when it comes to a jailhouse informant, everyone needs to know they are unreliable. Okay? They just are. They are unreliable. Your discovery in the jail is currency. So any piece of paper with anything about your case on it is currency for someone to try to curry favor with the government in order to get a reduced sentence or a more favorable outcome in their case or whatever the case may be, right? And one of the best things for any inmate is being in proximity, either a cellmate or on the same block with somebody charged with murder. Because then the state's attorney, that's what our prosecutors are called, starts getting all types of phone calls about this guy that just hit their unit and how he's confessing about the crimes. I had one murder case where we had 3 jailhouse informants, 2 of which gave versions of events that allegedly my client had said that were confessions that could not have been true, like completely impossible to be true. The state did their thing. They did what they were supposed to do. They turned over the jailhouse informant statements, but it was a clear, and they ended up using the one that wasn't unprovable or wasn't provable as false right away. They still used that guy, right? But anyway, it was a clear example of how people will use knowing that they're in proximity to someone charged with murder to try to get something better for their own selves. So they're completely unreliable.
I tell clients, like, don't talk to anybody. Everybody in there is, is a potential danger to you, and don't, under any circumstances, show anybody your disclosure, because if somebody wants to, to testify falsely against you, that is gold. Because then it's like, well, how did he know this? Oh, right. It's because he read it in the same page that,
Right.
that's how he knows that. So,
well, I have an interview up on my Rumble channel with a fellow named Dr. Jeffrey, I think it's Nauschatz, and he has an opinion. He's written some books on this. He is of the opinion that they should not be able to use jailhouse informants because they are so unreliable. His book was called Jailhouse Informants: Psychological and Legal Perspectives, and he's from Alabama, Huntsville, and so he's very critical of the use of jailhouse informants for just the reason there's such great motivation for them to lie and to fabricate.
I would love to see them do things like run a sting on the jailhouse informants and be like, oh, this guy keeps testifying. What we're going to do is we're going to put a cop in his cell with him to pretend to, and that cop is going to talk about, oh yeah, I'm charged with murder, but he's going to say no admissions, no anything. And then when that guy calls up to say like, hey, this guy confessed, it's like, well, actually we have a recording of everything that guy's ever said to you, and none of it was a confession. And now we're never going to listen to you as a jailhouse as a jailhouse snitch. But
they'll never do that.
They'll never do that.
They'll never do. They'll never.
Never
Because
do
they
that.
know. They
Isn't
know that
Runkle?
they're
He's
lying.
so cute and naive.
I know. I mean, that
Well,
would
I
be
mean-
great, but it's like the prosecution would never do that.
This would be fantastic, but we won't actually see it happen.
Right.
It's as much as I would love to see a lot of this stuff, you're never going to see it happen because they really like they like
love 'em.
these these jailhouse snitches.
Yeah.
So, and I mention this because the jailhouse snitch here, the informant, says that there's a heated argument that he snapped and shot him with a .38 that he kept in the ceiling of his basement. And you might go, "Ooh, well, he's got all this special knowledge." There's basically two ways this can be found out. Is A, they find it out through, or several ways rather that they can find it out. They get a hold of this guy's documents. That gets them there. They watch on the news and they see, oh, this guy was shot with, the police theory is this. And they're like, hey, he confessed to exactly what the news reported the police theory was.
That's right.
Or sometimes the cops will say, oh, did he mention anything about the gun being in the ceiling? And yeah, sure enough, the guy's like, yeah, he did. Totally. He said that. So yeah, it's, yeah. So he got convicted of first-degree murder and related handgun offenses. Once you're convicted of the first-degree murder, you don't care about the related handgun offenses.
No.
But then it was reversed, and so he wants to exclude the firearm identification office evidence of Scott McVeigh, who is their firearm examiner and so forth.
One of them, by the way, guys, just so you know, there's several firearms examiners in Prince George's County. Just letting you know that. And
Also,
one of them, oh, sorry, go ahead. Sorry.
Also interesting about the jailhouse informant, he testifies at the first trial, doesn't testify at the second trial. They just read in his testimony.
Oh, nice. That's terrible. Which you can do because he was subject to cross-examination in the state of Maryland, but he has to be unavailable for some reason. I wonder why he wasn't available. Was he dead? Was he up the road somewhere else and they couldn't get him into the state? I don't know. But Maryland does have a statute which is pretty helpful. That it just came into being. The prosecution has to disclose how many times that person has testified for the prosecution as an informant so that you can be able to cross-examine them on that. That's a recent change, I think 2021, 2022. It came into being while I was trying the double homicide that I finished last year. So that's something that's good. And if they don't do that, then that could be a reason to exclude the jailhouse informant. But in Maryland, you can't use that testimony unless the witness is somehow unavailable. So I wonder what happened to him. He's probably dead.
Or, I mean, is unavailable, because sometimes in Canada, they've applied unavailable for hearsay to just like, he won't testify this time. He's refusing to come to court, so he's unavailable.
I think it needs to be legitimately unavailable.
Yeah.
Like, see, if he's in custody, he shouldn't be unavailable.
No. He could
Yeah,
be
like they have to
different
make
standards.
efforts.
Yeah, or you could be unavailable through order of the court, which is like, oh, you assert the fifth, and you can't call a witness just to impeach them the entire time. So maybe he asserted the fifth, and the judge found that he had a valid reason to assert it. That's just. I'm not saying that that's what happened here. I'm just saying that's one way.
Here, we don't like jailhouse informants generally because
No.
they're very unreliable.
Yep.
And even confessions, people like confessions. I had an expert on Dr. DeClue on my Rumble channel. I interviewed about false confessions, and people really have it under, they really don't, Natalie and I have been in the trenches, and you see false confessions, you see people get up there and lie into the court. And I think average jurors don't live in our world, and they don't understand that people lie and that people falsely confess, and that the state presents scientific evidence that it's not scientific, that's junk science. And, and because we see it so much, that's why it gets us so frustrated, because we see this and it creates injustice. It convicts innocent people.
Someone asked, wouldn't that statement from the snitch be hearsay? And I was saying there's a hearsay exception when a witness is unavailable, and you can use their prior statement if it has been under oath and subject to cross-examination. So the witness cannot otherwise testify. For some reason, either they're physically like not alive, so they can't testify, or they're declared unavailable by an order of the court. And then they made a prior statement that was subject to cross-examination and under oath. That statement can then be admitted in its entirety.
Yeah, I mean, in Canada, they've applied different standards in different cases, and some of them I think are what I would call a fairly weak unavailable, if that makes sense. Like, hey, it would be too much of a pain in the butt to get this guy here.
Oh, no. That's horrible.
In some cases, it's also things like, oh, we forgot to subpoena them.
No.
Yeah, that should never meet the standard, but there have been some bad decisions here and there.
I believe
thankfully,
it.
that one hasn't really been followed, that we forgot to subpoena them case, but, you know, that can be its own issue. But so he wanted to, you know, exclude this, but the court says firearm and tool mark identification is still generally accepted and sufficiently reliable under the Frye-Reed standard, and therefore should not be excluded in its entirety. But they did agree that the subjective nature of the matching analysis made it inappropriate for an expert to testify to any level of practical certainty / impossibility, ballistic certainty, or scientific certainty that a suspect weapon matches certain bullet or casing striations. So that's a good decision for the guy. So, because that is typically what they want. That's the end point of this testimony, is to say, we match this. It is 100% that this gun fired this bullet. That's where they're sort of usually trying to go. I should note that the opposite of eliminating a gun may actually be a lot better and more reliable.
Oh, absolutely. You know, well, if you've got a 44 cartridge and a 38 gun, you know, it's obviously not a match.
Or the class characteristics don't match. Yeah,
exactly. Exactly. You know, and this is the thing. We aren't challenging the validity of the science of gun, you know, firearms. I mean, it's an operable firearm. It's a 38 caliber. It's consistent with all of those things are good. It's this matching idea that's that we're attacking, that's saying it's not scientifically valid.
It goes too far.
Even the individual matching, when you say that two things don't match, that's probably a lot more reliable than saying that two things do match. In the same way that if you're looking at our sort of scraper examination, you can say this thing, like the bullet that we're looking at, has this one particular gouge, and that isn't found in anything else. Therefore, this wasn't fired from the same gun. That's probably reliable. But if you say it's got this particular gouge, and that's a unique feature that would be seen nowhere else, that we don't know. How often does that gouge actually happen in a gun? We just don't know, right?
Right.
So I think that's sort of important, in that a lot of this stuff works better as exclusionary evidence rather than inclusionary. But it's also worth talking about sort of the history of a lot of these forensic sciences, because a lot of them basically start out with a cop has an idea, and then that cop starts a business marketing that idea. And so when you look at like hair and fiber analysis, when they're saying like, okay, we can definitely tell that this fiber came off of this car, like this car's upholstery. Well, that was started by a cop who had an idea and then started selling that idea to police forces. And it was used for, I don't know, a couple of decades before they went, oh, right, this is complete garbage and it's not actually useful.
Well, it's interesting. I would say that a lot of the, precede, I don't know how far we're going to go in the case here, but anticipating where the case is going, a lot of this came out from the benefits of the Innocence Project, and the exclusion of people from the walking people off of death row that were actually innocent based on DNA analysis. And DNA is a very strong and powerful scientific tool. And they found, I think there are over 1,000 exonerations, people that were put in prison, life in prison and death row, who were actually innocent. And because of that, people started questioning, wait a second, how did these false convictions occur? And that spotlight got turned on some of these fake forensic sciences. And Chris Fabricant, which we were trying to get on, wrote the book called Junk Science from the Innocence Project. And he talked about bite marks and how bite marks was fake junk science and convicted people. And if you see that, and then the turning point again came in 2008, and I'm cheating, I'm looking ahead at B, critiques. In 2008, the National Academies of Science issued a report. And then PCAST came out also, which is the other report. Those two things were blue ribbon scientific panels to look at the scientific validity of these sciences. And it's an excellent read for somebody who's interested in these forensics and the validity of these forensics. And they really cast a skeptical eye on this tool mark matching idea.
Yeah.
So,
and it's funny because when you think about it, like we've basically we've determined that bite mark analysis is garbage, and bite mark analysis is basically the same thing.
Thank you. Yes.
It's you use, like, your mouth is the tool in bite mark analysis.
yeah, good point.
So,
but the thing is that the bite marks it convicted multiple innocent people. And the idea, see, there is like what you said, there's people that are creating theories that which they say, oh, well, this is interesting, that the teeth marks, because we identify bodies from dental records, right? So teeth must cast a particular bite. And so therefore I can exclude, and there's a snaggletooth case, which I refer to in one of my books here. And they said, well, this bite was created by this person, so he must have been the killer. But then that's been falsified by the end. They've wrongfully put people in death row based on these false sciences. So we really need to examine the underlying validity of the theory that undergirds, for example, that you can distinguish between sequentially produced firearms, that they're going to create unique patterns on a projectile. That's an assumption, and it's not falsifiable, and it's not a true assumption. But it sounds like, well, I'd like to believe that, but it's just not true.
You're betting on a flaw, an individual flaw in production of each and every gun that comes off of that conveyor belt. And what I mean from that is the class characteristics; those are clear, right? You've got all the different ones that no matter what, you're going to know this came from, a Glock, this came from this came from that. But then in order for them to be individual, it has to be unique to that particular gun. Who's to say that every single gun is gonna have some type of unique characteristic, or something that you say is an individual characteristic is not something that just happened by accident to 10 of the guns that came off of that conveyor belt that day, of the 100 guns that came off the conveyor belt. So it really is assuming a lot. And I wanted to go back to the point that you made about the Innocence Project. This is an anecdote, but I think it kind of exemplifies it. I worked for the Innocence Project as a law clerk, which is a lot of the groundwork stuff that they do. It comes from the law clerk stuff, which a lot of places rely on. And when I was in law school, and I worked for an amazing attorney there in the New York office of the Innocence Project. And one of the cases that I worked on, the gentleman was convicted of an assault of a sexual nature on a woman in a Burger King that was working there overnight. And he was there with allegedly 4 other individuals that were all identified through different ways. And the way that he was tied to it was someone saying it was him, but also a shoe print, right? A shoe print. I went and I got some evidence from an evidence room. Just, this was work that had been built up for years and years and years. I just got into the case at a certain time. It's a case from the 80s. I happened to just be the one to go to the evidence room. This has nothing to do with me. This has everything to do with the attorney, who was amazing, who worked so hard on this case. That evidence was tested, the DNA, and it excluded him. He could not have been the person who was present at the scene with those other people. And I think 2020 he was exonerated. Okay, that's from like 1987 to 2020 that they relied on shoe print evidence to hold this man in prison. All of his young life, he was a teenager when he went in, right, and came out as a grown man. So I'm just saying that, you know, the things, there's things that are, we rely on it as our a CSI now, right? Our crime scene investigation science now. That's going to be our shoe print analysis of the future. We have to always check these things and challenge them, and not just accept them just because someone says that they're reliable.
Well, and the other thing is that we have to remember that they're not typically using the scientific method on this. And what I mean by that is that really everything that you do in science, you want to have double blinded, so that the person who's providing this information to the person doing the testing doesn't actually know what the answer is. But what ends up happening is that these experts who are like the bullet matching guy, they'll say, hey, listen, here's the gun we found. Here you go. Here's the bullets that we dug out of the dead body.
Yes.
Here you go.
Yes.
Our case depends on these two things matching. And he'll go and he'll fire, you know, into a water bin or whatever to get that fired projectile. So he knows that their case that they are building depends on these two things matching. And so he already knows what the right answer is, which is a problem because that's how you get BS answers. Really, what we should be doing with some of these, or, you know, we should have tests where we go to these officers and be like, hey, here's 4 bullets that we dug out of a body. Here's this. And they didn't actually dig them out of a body. They know that this is not supposed to be a match. And if the expert says, oh, yeah, it's a match, it's like, okay, great, you're fired because you can't do your job.
So I do want to say this about the Prince George's County office. It kind of like what you just said exemplifies both a problem and also, you know, the people that do this field, they take it very seriously, right? But anyway, a problem and a way in which they're trying to address the issue, but it still doesn't work because of the underlying science itself. But anyway, so in Prince George's County, they will do like a fake or mock-up. Oh, here's, you know, a bullet and a projectile and a gun. See if they match. And they'll think it's real, come to find out that the situation is not real. And that's, you know, then they have to include that in their, when you get the like underlying data about the analysts and their accuracy. And then if, you know, if they've been inaccurate on that, you can use that as a basis to cross-examine them. It's not going to get them kicked out, but, you know, whatever. Okay, fine. But the issue is not that. The issue is they give them the statement of probable cause with the stuff. They give them, they don't say like, oh, you know, like here's just a random bullet. They'll tell them the facts of the case. So it's like, wouldn't you feel invested if you knew that a 3-year-old boy was shot in the head? Wouldn't you try to make a match and help to solve this case? Even if you don't mean to do that, you're just a good person. You know what I'm saying? But like that unknown bias that you have in the background, I'm not using the most artful terms for that, but that unknown bias.
It's confirmation bias.
Confirmation bias. Thank you.
And it's also looking, I call it looking behind the curtain. And it's amazing how close these labs are to the prosecutor's office. They review the case file. And so they know what they're dealing with and they know what result will convict. And I don't know. I mean, how much does that poison the process? It shouldn't. There should be blindness regarding how much is that information necessary for the lab analysts to decide. I don't know.
I don't think any of it is necessary because in theory they should be able to, like, they're just matching bullets. That in theory shouldn't require any theory of the case.
Thank you.
It's either the bullets match or they don't. And if it does need the theory of the case, then we're probably not actually doing science. We're doing fudging. We're doing, you know, woo. So that I'm not.
I like that woo. Exactly.
So that, I mean, that's sort of the concern here. Is this really science, or is this just we can get some guys who will say some things that are really convenient for us?
Yeah,
So
it's a problem, and that's well. And Natalie, you're a trial person. We're both public defenders, and this is the edge between advocacy and justice. And you see these prosecutors who think it's their job to be an advocate, when instead of just following the law and wearing those blindfolds and weighing the scales of justice should be blind. Instead, they want to put their thumb on the side of guilt. And it's, by following the law, the prosecutors are upholding the law. But when they start putting their thumb on the thing and become advocates and take that advocacy role, which is our job as defense attorneys, but they think they start to become adversarial and they want to oppose and convict, that's when these errors run in. And that goes with police too. It kind of goes down the line. Instead of the police being an impartial witness and testifying to what they saw, heard, and smelled and touched, instead they start opining. They become advocates for guilt because they know better. They know the guy did it. And that's where the problem, you uphold the law by following the law. And prosecutors of all people need to be fully versed in the reasons for false confessions, for false convictions, because they are the ones that should be conscious of these problems in the sciences, in confessions, in eyewitness memories, all of these things. Prosecutors should be fully versed on that because they all have a lot of power, and by advocating like this on then pushing false science, it really it warps the system.
I think they genuinely believe in it, though. You know what I mean?
do.
Like, yeah, they from speaking to them, because I've had these debates, and as I always say, I have to move on from case to case. So I'll become an expert in this issue when it's happening, and then I have to be an expert in something else. I have to move on. It doesn't always necessarily stick, right? But when I'm debating the prosecutor about it in the case itself, they have a certain passion behind the scenes where they're just like, no, what do you mean? This ballistics evidence is, this guy is totally reliable. I've spoken to him in many, many cases, and he knows what he's doing, and he's had training for decades, and he went to the FBI Academy or whatever the case may be. They really believe it. So that's kind of like they get indoctrinated to, the ideal.
You also have to think of what the psychological costs are of changing your mind on that. Because if you change your mind on that, suddenly you've run this guy in like 40 different, cases, and then you might think, wait a minute, was I wrong? Did I put somebody in jail? People always ask me like, oh, you're a defense lawyer. How do you sleep at night? And it's like, well, the way some prosecutors sleep at night is by really not thinking too hard about whether or not they may have put somebody in jail, improperly, which when you think about it is way worse than what most of my clients have been accused of. Like my guy's accused.
I was a prosecutor for 6 years. And the thing is I think it's much harder to be a good prosecutor because it takes a balancing of interests. It takes a lot of self-discipline. It takes a lot of finding the truth, which can be very ephemeral. And as an advocate, it's very clean. I mean, I know who my client is. I put the state to their proof. Oh, cute kitty.
Thank you.
And and so I find, and when I tell people that I never lie for my clients, they're like, "Oh, you're just a paid liar." They don't believe me. I'm like, well, yeah, I don't lie for my clients, and people are amazed at that, but they don't understand the trenches.
No, I make legal arguments is what I do. I don't assert facts. I make legal arguments. So I'm not in the business of lying for anyone.
And put the state to the test, right?
That's absolutely right. Put them to their burden. Make them prove it.
And I won't, I've had situations where I've had clients who are like, hey, here's some evidence I want you to tender. And it's like, oh, this is clearly fake. And you need another lawyer because I cannot tender any evidence from you if you're, trying to get me to submit fake evidence. Like, you need a lawyer you haven't lied to. Bye. and they're upset. They're like, well, why can't we just use this? I'm like, buddy, like, this is not
Actually,
true.
in an appellate division, we have something called an Anders brief. And that's about half my cases. And those are cases in which there's no appellate issue. And when there's no appellate issue, I brief the case and I move to withdraw because I can't make frivolous arguments to the court.
Amen.
Right? I mean,
yes.
Trial is a little different. I mean, public defenders, we do have these ethical problems, but we work through them as we go to conferences to learn about, because sometimes we have to sit there and take the loss. Right.
Yeah, that's right.
But the job is to make the state put their proof. You got to believe the evidence, even if there's 10 nuns that are witnesses.
You're right. Listen. The way that I look at it is this: for me to be a good advocate for my client, I have never. Now, again, I haven't been doing this for 30 years, 40 years, like some of my colleagues have. But I have never been in a position where I haven't been able to say no to someone wanting me to do something I thought would compromise my oath to be candid to the court. You know what I'm saying? So it's just, if you're a good lawyer, you know how to make your arguments, like you said, hold the state to their burden, find the reasonable doubt, because that's my job, is just finding the reasonable doubt. I don't have to really advance a defense unless I really do have one, but it's just finding that reasonable doubt. If my client wanted me to advance some type of defense that is clearly just fictitious, I don't have to do that, because I get to choose the trial strategy. And that's one of the best parts of being a lawyer, is that you get to choose that. So I don't have to do that. I can just go with, the state didn't prove this case, right? They didn't prove this case, and that can win your case right there, because it's their job to prove it. So, and whenever people ask me that, how could you defend these people? I'm protecting the Constitution. They have a Sixth Amendment right to competent counsel, to zealous advocacy, and that's what we're doing. So yeah, I 100% believe in it, And this case is it. This case is like the culmination of the good work that we do.
Yep. Let's sort of catch up a little on super chats here and so forth before we get too far behind. Folks in the chat, if you haven't liked the stream yet, please do. And if you want to share it with other people, that's also encouraged. But I'm just starting by pulling up. Looks like we've got some gifted memberships. Summer Butterfly did a member chat with hands in the air. Starting by pulling up. And we've got Rhineman YYC member chat saying the only way to get scientific validity is by measurement. Start asking examiners how deep were the grooves in microns, please. I don't know that would, like, that's not usually the problem. It's that you have to determine that two things are the same, and is that actually proper?
And see, one of the people they're chatting and they're saying, well, the thing is it's a step too far. And Natalie, and we've had cases. The state doesn't need this. It's like, but they want it because it's such a powerful weapon, and we can't defend against, right? Which is why it's so appealing. But when they say, look, the guy was found with a .38 revolver in his pocket. It has 5 cartridges. One's been fired. There's a .38 cartridge bullet in his head, and he's sitting there, and the guy's got his gun in his pocket, and he just got done with an argument. And, and it's consistent with being fired from that gun. That's pretty darn good evidence, right?
I think it's probably
hard to overcome. You've got it enough. That is enough evidence to create and you create good police work creates the circumstances. You've got eyewitnesses. But when you take this extra step, you run the risk, because it's false. It's not falsifiable by the defense. It's powerful. It solves the question. It answers the question scientifically, and there's no way. And we're defenseless against it because there's no way to falsify it. You see, so so this is why it's a problem. And I'm not saying, we're not questioning any of that other evidence. And people go down all the time with good police work, validly obtained evidence. Right?
I think in this case they probably could have gotten a conviction without jailhouse informant and without the ballistics, because it's like, these guys were fighting. Police were called 3 times.
Right.
This guy owns a .38. You like the fact that it's 38 is, we're all in agreement that that's sufficient.
Sure, right. They're probably going to get him anyway.
Yeah. Right. The argument would have been, who else would have done it? who else had the motive and the opportunity?
Well, there's a burden shift there, though. You got to be
Well, no,
careful. You're
well,
putting your
got it down to
prosecutor
like
hat
a
on. Natalie's the prosecutor.
I'm
They've
just
got it, like,
saying,
to
you
a
don't say that
15-minute
exactly,
yeah.
but
Yeah. Right.
you
But
don't
they've
say
got
that
it to, like,
exactly,
a-
but that's it.
Well, and they've also got it to like a 15-minute period after the cops leave that this happens. I'm like,
Yeah.
the chances that this was somebody else, or like, what's the defense argument going to be? This guy
That-
got a hold of this gun and shot himself 5
That's-
times.
That's what I'm saying. Exactly. It's like,
You know,
and in the reasonable doubt jury instruction in Maryland, it has this thing about like common sense. Like, you do not set aside your common sense. And if a good prosecutor is just going to be like, oh, what's the common sense answer here? You know, these guys are beefing. He has a gun. It's the same caliber as what's found in the guy, and they live together. Like, oh, did some random person just come in the house to do it? Probably not, right? And then, of course, there's the opening to argue from the defense, like, probably not is not beyond a reasonable doubt, but that common sense, you know, don't put aside your common sense. That carries a lot of weight in a situation like this.
And Brian in the chat is saying there's 4 days between the body being discovered. You can argue that,
right.
But is the jury going to say that that's a reasonable doubt, or are they going to say really the only inference we believe in here is that the guy got shot with those gunshots that were heard the same night? I think the jury would get to this and say, we're good. Like, we got a conviction here. We'll put this guy away.
And you also have the medical examiner report saying how long the person's been dead. Compare that to when people heard the gunshots. It's just, listen, I'll say this. In murder prosecutions in Prince George's County, if any of you are watching this, because sometimes they watch me on stuff, but I don't think they're in here. Sometimes they watch me. If any of you are watching this, I will never admit that I said this, right? But in our murder prosecutions in Prince George's County, our murder prosecutors, they really try hard, okay? They don't phone it in. And that is actually saying something, unfortunately, but they don't phone it in. And they are more of the, let's throw everything out there and see what sticks, you know, like, and that's good. If I was killed, I would want for that prosecution to be my prosecution for the person who killed me, right? Here's the problem, is that they are more effective when they know how to dial it back. In my murder case, which I said to you guys, it's probably coming back on appeal. We have the same exact issue that I had with the same issue, with the same expert, all this type of stuff. The prosecutor also, in my case, it's a different prosecutor, did not need the ballistics. And I think they got second. They would have gotten first had they not used the jailhouse snitch and the ballistics, because I tore up the jailhouse snitch and I tore up their ballistics expert. And I feel like the jury just kind of gave us, like, you know, like, we're going to give you a little something. We'll bring it down to second instead of first, because if they believed he did it, it was, you know, it's first, right? So anyway, the thing I'm trying to say is this: they feel a way about losing the ability for these experts to say it's for sure this projectile came from this gun, but it actually protects them more, because when you overreach, you open yourself up to cross-examination, where it's just like, okay, well, you didn't do this testing, you didn't do that testing, you don't know how many individual characteristics have to agree, and it really calls your science into question when you overreach. And this court is just bringing them back to reality and just saying, you cannot say that there is a match.
Yeah, and I think that makes sense. I've got some additional. So Equality, thank you for 5 gifted memberships.
Oh, they're the best.
Oh, Equality is on a lot of streams and is just a wonderful, wonderful person there. Susan Davidson saying, thanks guys for this, as I can't sleep. That's a common peril for me. Tony P, thank you for the membership. Emma Moore, thank you as well for the YouTube membership there. Mike DiRado saying, I'm so sick, but I wanted to send love and support to 2 of my favorite YouTube personalities. Steve, I'm sure you're awesome also. Love you guys.
I think this is my first time on your channel, so thank you.
I think it is.
Feel better, Mike.
Yeah.
Feel better, and hopefully people get to know you, because you're a guy who's got a lot of knowledge and a real passion for the courts getting it right, which I think all we really want to see here. Amber, thank you for the YouTube membership, much appreciated. We've got Nicholas Staro's Trial Watch. Hey ho, happy solstice. 100
Nick.
years of allowing stuff in men's nothing. 100 years ago, phrenology was a science.
Yeah.
Yep.
Yeah.
For the people in the chat who don't know what phrenology is the idea that
The little sections on your head.
they basically had an idea that criminals had a particular shape of their head, and so they actually used to measure people, and like they would determine, oh, hey, this guy's probably going to be a criminal because look at his head shape. And
yeah, what about the humors? The humors, that was one that was like 100 years ago, like the bile or something like that. Like that was like a way to like you had to balance the humors in order to make you like not sick anymore, and they would like stick leeches on you. That's what we were doing 100 years ago.
It's true. We keep talking about all this progress we make, and sometimes it feels like we're kind of going in circles in some ways. We just
but in order to let's seize the progress and apply hard science and a hard look at these things that we are presenting to juries, and that's kind of what the court here has done, is taken. This is what you call scientific progress, and I think they've taken a healthy bit of skepticism, and and the conclusion here is exactly right. It's exactly right. What they're allowing in there, because this is not just a straight reversal. It's an affirmance. It's an affirmance and a reversal. It's one of those mixed things, because they're saying it's okay for him to come and testify about this is a 38 caliber bullet. This is a 38 caliber firearm. This is consistent with being fired from there. And that's it. And that's enough. And a lot of times that's enough. And it should be just enough, because going the extra step is what causes the false conviction. So the court got the balance exactly right, and it's by applying real science and not advocacy, faux science, junk science.
Yeah. Mm-hmm.
And we've got a comment here. Whoa, Runkle, that's categorically false regarding ballistics. The Forensic Sciences Division in Ontario is blinded. Otherwise, evidence provided would be torn apart. I don't know about Ontario specifically. However, in terms of blinding, very common errors for blinding would be an officer who's involved in the investigation provides the evidence to the person, because then they may talk or they may communicate things. The other thing is that if they aren't giving known bullshit to the forensic guys, like if they aren't intentionally giving them like wrong things, then it's not blinded, because the forensic guys are only getting stuff that the police want to, investigate. That's not a blinded study. That's one where they know that everything is
and digging
spicy.
into the opinion a little bit, they talk about after post PCAST, the post, once these things have been subject to question, right? And I see that Tobin is the expert, and he is a great expert. We have him on a case come in, and he wrote kind of the paper that started a lot of this ball rolling about questioning the science there. And the Ames report is the only one that has any kind of black box scientific validity, right? Well-designed study. And it's interesting, the advocates for this junk science of bullet matching say, oh, it has like 1%, less than 1% error rate. But they lump into that the scoring of don't know. And so, and I was on with another channel, and they were saying, well, that's sort of like taking the SAT, and you get all the right answers that you choose, you get scored, but the ones that you skip don't get graded. So I skipped 90 of the 100 questions, and I got 10 of them right, and those are the ones, so I got 100%, right?
Right.
And that's what they're saying here. And when you lump in the don't know questions, which should be lumped in there, you're talking about error rates of upwards of 60%.
Go ahead.
I actually had a test like that in university, and the prof, he actually thought it was quite funny because I answered one question.
Right.
And he said, basically,
right. That's it.
You only get scored for the questions you answer. So I answered one. And he's like, I've always thought that was the right way to do it, and nobody's ever done that before on my exam. I was like, So he's like, yep, that's why this is like a 10% exam and not like the big exam. He's like, but that's the problem. It's a bad way of looking at it, and it intentionally, like, these bad tests cook the books.
That's right.
Yeah.
That's right. So I wanted to point out something. Another issue with this whole ballistics thing and like how they grade things is that they will say, instead of saying something is excluded, they'll say that it's inconclusive a lot of the times.
Yeah.
In order to try to bolster, the matching. So there'll be like other projectiles that maybe could have come from another gun, and instead of saying that it's excluded, they'll just say that it's inconclusive. And there's really no standard between the difference between excluded and inconclusive, which is very, very, problematic to me.
Yeah, and inconclusive is it gets to be a real problem in terms of it being fuzzy, right? Are we doing science or are we not? And I mean, it might be something like, hey, I can't do an analysis on this one because the bullet is too destroyed. Like that can happen. Like the bullet is just turned to powder. But a lot of it is like, I don't know, but they'll treat that as a yes, right?
That's right.
Well, another interesting thing they do here is just, I love this, and this is in the Ames report, I believe, is they do the reproducibility. Somebody mentioned that in the chat. They said comparing the results from the second phase to the results from the first phase. So what they do is they take the results of the matches, right? And then they funnel it back into the system and have people try to replicate the result. And here on the non-matching sets, proportion of paired disagreements 37.8%. So within the subset of over 37% of the time, they couldn't reproduce the results that they came up with. So that's a huge problem of reproducibility, which is part of science. Like we test gravitational theory all the time, and because we can reproduce gravity because that's science. But when you can't reproduce your results in 37+% of the time, you've got a problem with your science.
And I do want to point something out, Steve, just to give the, I don't like the term devil's advocate because the devil doesn't need an advocate, but just to kind of anticipate that maybe somebody will stumble upon this video who just really has I was about to use a very inappropriate term, a love for ballistics evidence, right? And is an advocate for ballistics as being an exact way to match a projectile to a gun. There have been articles and studies that have come out after the PCAST study that have called into question the PCAST study's challenge of the PCAST didn't only focus on ballistics, by the way. They talked about other forms of CSI evidence and their challenges and how they were either reliable or scientific or non-reliable and unscientific. But anyway, there have been other studies that have come out subsequently that have challenged the PCAST study. And prosecutors will point to those when you're challenging ballistics evidence. By and large, they are industry studies, meaning people that are ballistics experts. So they are invested in keeping ballistics as a field because it gives them a job, or in some way funded by gun manufacturers because they're intertwined. There's like a regulatory capture between the ballistics experts and the gun manufacturers. I
didn't know that.
Yes, they go to the I've been saying Glock a lot, but what's another one? Beretta or whatever. Like, tell me another gun manufacturer.
Beretta, Taurus, Sig Sauer, High Point.
Right. Yeah. Okay. Thank you. They'll go to those factories and they'll do a industry study. Where they'll look at all the different guns that are being produced and the different component parts. And it makes sense in order to add it to, we know that these are the class characteristics. We know how common a certain gun is. But you think when they're there, they just look at stuff and go home? No, they have a little lunch. They have a little drink. They hang out. You know what I'm saying? They're chilling. And now I'm an expert on Glocks, right? I know everything about Glocks, and I go to Glock conferences, and that's how I know so much about these guns. So there's a bit of a capture between the industry of gun manufacturing and the ballistics experts. And I'm saying all of that to say that then the gun manufacturers will fund reports about how reliable ballistics evidence is, which is a conflict. So I pointed to that in several of the cases that I've litigated where they've challenged the PCAST study based on studies that were funded by the gun manufacturing industry. I don't have a problem with the gun manufacturing industry, but it's not unbiased, is all I'm trying to say.
In going to that, again, going back to the case, echoing that, that's interesting. I've got to think about what you said there because I hadn't considered that, and thank you for that. But one of the things the case kind of centers on is this AFTE organization. So there's an organization wherein there is they all sit around and agree with each other. So there's no external validity. When they publish a paper, they say, oh, there's all these papers that have been published. Well, they publish the papers within the AFTE organization. They don't put it out into the public. They don't put it into scientific journals. They don't question their own conclusions and fundamentals of their science because they're all in the organization and they sit around and agree with each other. And anybody that doesn't agree is not going to be flying along in that organization. They're going to get the boot. That's why you need an expert, somebody like Tubin, who's an external person, who's a scientist, who's going to come in and say, wait a second, you have problems with your science here. Because internally, there's just too many pressures within big organizations to conform. Mm-hmm. But they do talk about that in the case about this AFTE kind of circular firing squad, so to speak, right? Where they all agree, they all sit around and agree with each other, but that is not good enough. We need to open up the process as much as possible, allow external evaluations like Ian up here is talking about, designing some studies, designing some real credentials. Oh, in one part, they even say there's a test and we're certified, but nobody ever fails the test.
Yeah.
So what kind of test is that?
Ian dropped the bomb. Ian dropped the bomb. I know you've been waiting so patiently. Do it.
We've got this comment here. I would strongly recommend the lawyers here take some mathematics courses, statistics, as well as some general science courses. Understand evidence-based science. Finding the truth is the ultimate goal. I did take stats classes and I took research design classes, and that's why I'm so annoyed by a lot of this, is that this is done in ways that are exactly how we tell people not to design studies, exactly how we tell people not to do research. This is, and if you apply the standards of good research design and good practice to these, they fail so badly. They fail terribly. And that is, that's really what I'm looking to do with this challenge. I'm going to write it all up. I'm going to write it up properly as like, here's the protocol. And then I'm going to start reaching out to firearms experts who've testified and say, hey, here's the challenge. Do you want to, I've got $1,000. Bronca has matched that with 1,000. So we up to 2,000. I think if more defense lawyers hear about the challenge, we may get more people going, hey, and it'll just be, if you successfully go through this and can do this bullet matching task which will be set up with proper sort of proper design, proper stats. And if you can do it, you'll get the money. But if not, I get to tell everybody. That's the challenge. And I don't think we'll get a lot of takers. And that's
the key is going to be to design. We really need to work on the front end to have a scientifically valid design of the test. Yeah, we really need to front end. I was telling you earlier beforehand that I have a friend who's really good at grant writing. And if we design a test, we might be able to get it grant funded, and get some academics to really put some time, because this is what our educational system, this is what the academic world should be focused on. You know, our criminal justice programs should be focused on validity testing like this. And it would be great fun to test out a bunch of Glocks.
I want to contribute to this, to my two very esteemed colleagues above me here, that I'm in a bit of a different position, okay, when it comes to the whole Natalie, go out and learn science. I will not be doing that. Instead, what I'll be doing is deferring to the amazing forensic attorneys who are in my statewide office, who have scientific backgrounds, and
Yeah.
the experts who we hire to give us the cross-examination tools or to testify and call into question the ballistics experts. Lawyers, for the most part, unless, they are just these amazing people above me, lawyers for the most part can't go and learn every single field, but what we can do is consult with experts. So I consult with experts, and the scientists that I speak to that I trust greatly, that I've called upon in multiple cases, take issue with the way in which these conclusions are drawn in forensics firearms examination. And so I trust them. And according to the Supreme Court of Maryland, they were right. They were right.
I just look into a few areas because they interest me, but whenever you want to get like at a really deep level, you have to go to, like, as a lawyer, you just can't devote 10 years to becoming an expert in something, because hey, we need to adjourn this for 10 years. I need to go get a PhD in this field is just not going to happen. But we were earlier talking about the standard of the abuse of discretion, and the court describes it here in a way that I think is really nice, which is not just it's not just that they disagree. They say an abuse of discretion occurs when no reasonable person would take the view adopted by the circuit court, or when a decision is well removed from any center mark imagined by the reviewing court and beyond the fringe of what the court deems minimally acceptable. Which means that acceptance of this firearm evidence is at beyond the fringe of what the court deems minimally acceptable. That's a harsh result.
Yeah. We're kind of hurting over here in Prince George's County because Judge Pearson is a very well-liked judge. He really is.
It's cute. I love the fact that you're local, man. That's so cool.
Yeah. So he's like he's a well-liked judge, and it's a deserved reputation that he has. Just a consummate professional. Let's just put it that way. But it's just the ballistics is such bull crap, man. If you're going to be saying that it's an exact match, and so I'm glad they reached the decision that they reached. I just hate it was with this judge. I hate that. And I'm always going to be honest with you guys.
Well,
I have
sweet.
A personal bias.
That's so sweet. Well, it's funny. I remember I had two lawyers who were partners, or they shared an office. They're both solo practitioners. Mm-hmm. And one of them got a 3850, which is an ineffective assistance of counsel complaint. And they were writing the ineffective assistance of counsel motion against the attorney that was right next to him. And he's like, "Hey, I got this new case. I'm calling you ineffective." And it's like, go get him, right? Yeah. So, I mean, there is a certain professionalism involved here.
No. If there's an appellate issue and I was the trial lawyer and the appellate attorney has to say I was ineffective, I don't care. Do the best that you can for my client. You know what I'm saying? So that's ultimately how we feel about it. I'm glad they reached the decision that they reached. It's just such a weird position to be like, not Judge Pearson. Are you serious? But
yeah, it's. I think that it's fair to say that this is a case where it's not sort of specific to this judge. It's just that they're making a ruling of, this is. This is just going to be the new way of looking at things.
It could have happened to any judge. This is such a great opinion, though, for the whole country. Every state, every attorney, every prosecutor should be reading this opinion and taking it to heart, because what we do not want is innocent people being convicted on junk science. And you have a responsibility, if you're a prosecutor and if you're a defense attorney or a judge, to really make sure that the evidence that we're using is solid. And the conclusion of this court, one thing that we should really do is read the conclusion, because it gets it precisely right. Mm-hmm. It gets it precisely right. And that's so refreshing, having seen my boatload of bad cases come out of appellate courts. It's great when you see a top court doing it right. So I don't want to leave the stream before you read the conclusion, because it's great.
Oh yeah. Well, here they describe, I think we've already covered sort of the what they're looking at there. I don't know how much detail the chat wants us to go in.
Well, there's a couple. Check out just before D, the existence of maintenance standards and controls. See if you can find that.
What
Do you have
page
the
is
page
that
number?
on? Yeah,
Should
the
be page
number?
17, I think.
You're almost there.
B.
Oh.
Let's see.
No, I'm at B.
Look at D.
All right, we're scrolling down to find D here.
They've got charts in this opinion. I love it.
I know. How about that? We
Go
do
ahead.
math. I'm
And
impressed. Lawyers are doing math.
I don't know if we said this at the top, but Supreme Court of Maryland, that's the new name. We might have said that already, but that's the new name. So they're like, they came out swinging. Like, we're now the Supreme Court of Maryland. We've got charts, okay?
Yeah, no, and I mean, it's good to have the numbers there, right?
You know, it's very good. Very good.
What is it? An examiner classing the same non-matching bullet or cartridge case did so at 60, about 65%. That's not great accuracy for something claiming to be science, right? They're not getting the same answer, or
that's actually less reliable than polygraph.
Yeah.
Yeah. So, and polygraph is not admissible. I don't know of any courts that admit polygraph. Mm-hmm. So, if you look at, I'll just read it. I don't know, you have to get into it, but it says, get to D. Oh, it's not that one. It says, a conclusion that a bullet was found in a victim's body was fired from the defendant's gun is likely to lead to much more directly to a conviction. Mm-hmm. That effect is compounded by the fact that a defendant is almost certain to lack access to the best evidence that could potentially contradict or, of course, confirm such testimony, which would be that bullets fired from other firearms from the same production run. See, this is one of the reasons that added scrutiny, and they lay it out so well. This case is so good in so many ways, that evidence is so damning and so likely to result in conviction that we need to be absolutely sure that it's good science. And we have 60%, reproducibility. That is very weak. But the jury's going to hear it's a match, and they're going to think, oh, well, that's it. It's over, right?
It's a match.
Then the defense not being able to rebut that because you have no way to falsify that opinion. And it's so it needs to be limited at the pretrial stage.
65% is barely better than coin tosses.
Yeah, it's barely better than 50-50.
A coin toss will have 50% reproduction. Like, hey, you got heads last time. You got a 50-50 chance of getting heads this time. It's it's not great at all.
Here's another part in the analysis section of the opinion. Without the ability to examine other bullets fired from other firearms in the same production run as the firearm under examination, the record simply does not support that firearm identification can reliably eliminate all alternative sources so as to permit unqualified testimony of a match between a particular firearm and a particular crime scene bullet. It says it. I mean, it's this case is just so full of excellent thoughtful analysis of this issue. And this is the best case I've ever seen on this issue. It's so right on point, and it needs to be spread throughout the United States.
And let me just again give my unique perspective here. It's a little surreal that this is of such interest to people outside of Maryland, but it's important to all of us. I don't fire me for doing this, OPD. I must shout out Jeff Gillerin. Jeff Gillerin is one of the attorneys who worked this and on the appellate level. And Jeff, when I tell you smart and dedicated to tearing down junk science. When I was a baby attorney on the Eastern Shore of Maryland, he came down to my district court DUI case to challenge a drug recognition expert. And he came down, he helped me fashion my cross-examination. He helped me to interview the drug recognition expert. After his work in that case, we almost never use drug recognition experts in the state of Maryland. I haven't seen them really since. He is making he's changing laws in the state of Maryland without being on the legislature. That's the type of advocate he is at the appellate level. And he's amazing. And I just really want to shout him out, because a lot of this, the language that the court is using here, this is verbatim things that Jeff and Drew Northrop in my office have told me and said, say this, right? Argue this when you challenge this expert, and I've done it. So they don't just do the appellate work. They help the trial attorneys to make the arguments so that it will preserve the issue so that they can attack it once it gets to the appellate level.
Yes, this is what we appellate lawyers do. And we love it when a plan comes together, right? And so I love it. I love advising our trial division. I'm actually board certified trial lawyer, but I've moved to the appellate division, and I love strategizing and helping out our trial division on these type of things. Because, and then like you, and it's thank you for being appreciative to us appellate folks, but it's so much fun because it's a team. And one of the things about our appellate office and our public defender's office is we operate as a team, and we help each other, and we bounce ideas off each other as a group, and we get the best out of each other. And so like you have skills that us as appellate people don't generally, and vice versa. And so we get the best out of each other and hopefully get a result like this. So thumbs up. Maryland gets a big thumbs up on this one.
And
I'm so
MLS.
Oh, go ahead.
MLS Law Show, there's the citation, but also if you reach out to me on Twitter, I can shoot you a copy of the case.
Mm-hmm. It's a great read. It's long, but it's a great read.
It's long, but it's fantastic.
I will say it's the way an appellate decision should read. It's very thought out. It's very deliberate. It's very analytical. It's very it's structured, and it puts the test. It's so coherent and well drafted. I'm so impressed, and I would love to see more opinions like this out of our appellate courts, because they do the hard work. This is not and like you said, it's probably a lot of it's being lifted from the appellate briefs, but that's okay. I mean, at least they're doing it, because the appellate briefs don't get bandied about on Westlaw. The opinions do, so they need to write like this because it's important for our clients.
Yes.
Well, and I love this bit here about saying like that, oh, we get our work checked by a second forensic examiner, so that's going to be better than these studies. And, he said that the error rates are overstated because the studies do not permit confirmatory review by a second examiner. And then they go on, however, Dr. Hamby also testified that the confirmatory review process is not blind, meaning that the second reviewer knows the conclusion reached by the first, which in and of itself is terrible. And then the next bit is even more significantly, Dr. Hamby testified that his decades of experience in firearm identification in multiple laboratories in multiple states, he was not aware of a single occasion in which a second reviewer had reached a different conclusion than the first.
Absolutely right. Someone asked what a drug recognition expert. Can I answer that real quick, Ian?
Yes,
okay?
Absolutely.
Okay. So, so when I say that, you might think like, oh, it's just a guy looking at some drugs and being like, that's Percocet, and like, no, it's worse than that. It is in traffic stops where they're doing the field sobriety test with someone, and the person will blow and it's a 0.00, but they think that because of how they're acting, they must be on something. So they'll take them through a series of field sobriety tests to recognize drugs in their system. But there's been like no studies on the accuracy of that. And it's not like alcohol where it's like, it doesn't matter if it's tequila or vodka, it's still alcohol. And it will have, pretty much a consistent effect on people if they've drank too much. Whereas with like, is it cocaine? Is it PCP? Is it heroin? They'll look at someone and say, oh, they're on a drug and they're suffering from the effects of a drug. And there was just no science to back up that a person could look at another person and tell that they were on a particular drug based on making them walk in a straight line versus do they have a neurological disorder or do they have a prescription medication or something like that. So it was challenged all across the state with the help of our forensics department. And for the most part, they really don't use them anymore.
I had a case where the Crowns, they had screwed up on the breathalyzer.
Mm-hmm.
and they actually got no result out of the breathalyzer. It just wasn't working right. They actually like they needed to maintain and repair the machine after this.
Mm-hmm.
So they were relying on their observations of this guy's demeanor to show that he was intoxicated.
Sure.
And their theory was that he was drunk. They didn't say that they smelled alcohol in his breath, but they said that he was slurring and that he was having trouble walking. And so they said, this guy is clearly drunk. And they had video of him walking very poorly and like literally hanging onto walls to stay up. And so the Crown's like, I'm pretty sure I've got this. It's a great case. And I said, I don't think you're going to win today. I think you should call this. And they're like, well, we've got audio recordings of his voice. We've got him. And I said, okay, you need to know, like, my client's got, he's disabled. And they're like, well, we'll run this. So they go and they would go to trial. We're running this impaired trial. This guy comes, like, my client is there and he's walking on a cane. And when he was pulled out of the car, they didn't let him get his cane. So obviously he's having trouble walking. And he gets up on the stand and I just start off with, is there anything we're going to notice about your testimony today? And he says, I had a stroke. And he can't speak very clearly because he's got left side paralysis. And the Crown just stands up and says, we're calling no further evidence. We're good here. Because it was the same voice, right? The same thing that they had on the recordings. And you just can't tell, right? You can't,
right.
And that's the problem, is that assessment, that visual assessment of this guy, they can't confirm that it's intoxication. It's just that's their feeling.
Mm-hmm.
Well, and one of the key factors that needs to be remembered when dealing with these things is the burden of proof. And a lot of people are questioning about us public defenders, defending the guilty, right? The burden of proof is always on the state, and it should be. And that means that when they are trying to advocate to present this kind of evidence, the burden is on the state to prove that it is valid, not on the defense to prove that it is invalid. And so this is one of the things that you need to remember when, and it's this type of extremely damning evidence, before it comes in, the state needs to prove to me and to the court and under Daubert factors that it is reliable, it is scientific. It's not, now we're throwing rocks and we're saying, well, we can't disprove it, right? And that's true, and that's a problem with it. But ultimately, the burden lies with the state to show that this is valid science. And at this point, it is not. And that's what the court's conclusion lays out what they can say, because there's a lot here. There's a lot here that the firearms experts are going to say that's going to put away 99% of our clients, right?
That's right.
But it's that extra bit that is so problematic. And go ahead.
Yeah. Well, you were talking about the failing. Here's the section on them getting tested. As a second example, although advocates of firearm identification tout periodic proficiency testing by Collaborative Test Services Incorporated as a method of ensuring the quality of firearms identification, the record contains no evidence supporting efficacy of that testing. To the contrary, the evidence suggests that examiners rarely, if ever, fail CTS proficiency tests. Dr. Hamby confirmed that the industry's mandate to CTS with respect to proficiency tests was to try to make them as inexpensive as possible.
Cost. That's a blow. That's a blow. Cost is more important than accuracy. Nice.
And Torres gifted 10 memberships, by the way. Just want to
thank you very much.
That's
yes,
lovely.
I've got my mod is tracking all of that, and it's hard to sort of figure out when to cover all that. But thank you very much.
And Natalie, I wanted to ask you, because I'm pretty sure the Innocence Project was also involved in the setup of this case in a lot of the briefing. Do you know how much input that they had?
No, I don't know. And I don't know that they did, actually. I thought that this was just OPD, just because it hadn't got to the post-conviction stage. He hadn't lost his appeal, but I could be wrong. I'm ignorant on that. I'm ignorant on the involvement of the Innocence
I had
Project.
an interview with Chris Fabricant from the Innocence Project on my Rumble channel.
Okay.
He's the author of The Junk Science, and I know that he's director of strategic litigation. And I
Mhm.
believe I was trying to get him on this stream, but he had
Mhm.
other obligations. I
Mhm.
believe their organization was involved in this.
Ooh.
Yeah,
I love that. I love
and
that.
this is something that they're challenging. There have been people that have been convicted with this junk science, and
Mhm.
we public defenders, we go to our conferences and we go, and I don't know if you have it in Maryland, but there's
We
the
just
guy
had
that
one.
walked off death row, and you get to talk to him one on one and
Yeah.
see the human
Yeah.
being behind these exonerations. It's quite
That's
moving.
right. That's right. And as we just had a conference, and we actually just had kind of like an office wide in my office in Prince George's. We had a client who's recently been exonerated. Our attorney on the trial level. Oh, she's just amazing. And her client came back after being exonerated. He's a much older person now, and we had a party for him. So those events, and then like I told you, one of the people I worked with on the Innocence Project, I had his case in 2009, and he was exonerated in 2020, and he was convicted in 1980 something. And him being exonerated all these years since, it's something that still sticks in my mind, just that yes, there are people out there. He went in as a 17-year-old boy. There are people out there that are in prison right now that are innocent. They're factually innocent. They did not commit the crime, but there's some junk science that convicts them, and it's terrifying. It's why I'm energized to do my job every single day. I don't care what anyone thinks about it. It's for that one guy or girl. It means something.
Well, and something else people need to realize about us public defenders, and we do have a case here, but I want to make this point, and they're like, well, how can you defend the guilty? I've got an essay rattling around my head about that. And the thing is a lot of times, okay, yes, they're guilty, but what is the sanction? Okay, so you got somebody who throws a rock and breaks a window of a car. All right.
Mhm.
Now it's, throwing projectiles, or it's some felony. Is that a 5-year prison sentence? But but you get these prosecutors who are like, that's what they want. They want 5 years. He's a bad guy, or put him away. Is that really? So a lot of times it's like, okay, yes, he did it, but the sentence is so out of whack. I mean, I know the example I like to use is I had a case on appeal that was a woman who stole. She was a 48-year-old woman. She stole a can of spray paint from Walmart and got 19 years in prison. Exactly.
Oh,
And so it's like, well,
Florida
she's guilty.
man.
How can you defend the guilty? I'm like,
Right.
well, because that's a ridiculous sentence.
Was it some type of 3 strikes rule or something like that?
It was a score sheet problem. When she was 18, she was in Kansas, and she had a bunch of prior firearm robberies, which she did 10 years in prison in Oklahoma. So
Mhm.
she got out, and then there was one prior felony within the last 10 years. And so her score sheet came back and whacked her and had a min-man of, and it was a felony theft, petty theft,
Because of
because
the
it was her
amount.
second petty
We
theft.
use we use score sheet as a different bit of jargon here. Where I am, score sheet refers to like drug dealers having
Mhm.
records of their who owes them what and what they sold, because drug dealers do
Mhm.
accounting too, right? They want to
Mhm.
keep track of it. So that's what a score
Mhm.
sheet is here. And
Mhm.
having one is a really bad idea, because if you get pulled over in a car and they find like 2 grams of meth and a score sheet, now you're looking at a much more serious charge.
I
than-
think that's a uniquely Canadian thing to have an accounting of your meth dealing. That's
Well-
like you guys are something else. Trust me when I
Canadians, I don't know about these
you
Canadians.
guys are so like orderly and kind and nice that you even have score sheets for your drugs. I'm telling you.
I'm surprised at just how many drug dealers like sell drugs on credit. Like, yeah, it'll be like, hey, I don't have any money, and it's like, well, I know you're going to be good for it, so I'll let you borrow some money.
Well, then you
And
might
like,
get your legs broken.
but oh yeah, it's a great way to get killed.
Yeah.
Owing drug dealers money is a great way to end up with some serious violence against you. But they have to keep accounting of that. Like they'll like, somebody's like, oh man, I don't owe you anything. They're like, look here on the page. You see how it says
You know
And
what? I haven't done drugs in a while, as in exclusively drugs. Usually, I have not handled a drug case.
Okay.
Oh my God.
I don't know about this. Who am I hanging with?
Oh my goodness. I haven't had a case where the only charge is drug dealing, right? It's usually like there's some violence involved. The drugs are kind of ancillary to everything else that's going on. I am thankful for the fact that in none of my cases has there ever been any written like, oh, Tommy owes me $30 for the crack, like, thank goodness.
One of the worst
in Florida, a score sheet in every felony case, there's a score sheet. It's supposed to reduce bias in the sentencing. It's supposed to provide consistency. And generally it's a good thing. The problem is that sometimes it can result in very unfair sentences. And in this case is one that I rant and rave about. And I use it as an example when people say, how can you defend the guilty? Because sometimes it's outrageous. It's like the solution to every problem is prison. It's like sometimes you've got people like, domestic violence, as we deal with a lot. And families need the intervention of a police officer to separate the problems. Natalie's still regretting that statement.
Oh my God. I'm sorry.
Right?
I'm so sorry. That's not what I meant at all.
So, and so the thing is people need that help at that moment, and the police separate them, and then they get back together. But this is their loved one. This is their son or their child or their wife. And then it's like, okay, now they want to get back to their life. The help has helped them. But now the prosecutor wants to put that person they love in prison for extended periods of time. It's like, that's the breadwinner. That's the person I love, the person I married, my child, whatever. Mm-hmm. It's like, we don't need prison here, right? And so it's like, well, they're guilty. It's just always, there's a compassion level that, and I guess that's why it attracts people that are, high in compassion and empathy. But seriously, a lot of the prosecutors just see our clients through a notebook, through a file, through a criminal file. When we see them face to face and we deal with them as human beings, and maybe there's a bit of Stockholm syndrome sometimes, but they're real people with problems, right? And it's not always is prison time the solution to that problem.
I had a trial where my closing submissions were, my client is guilty. The question is what they're guilty of, because essentially it was a shoplifting, and as my client is running away, they toss the product which was a bottle of liquor, up over their shoulder, and the person who's chasing them got clocked in the head. Oh. And so they're saying that was force plus theft equals robbery.
Oh, come on.
But the question is, were they actually trying to smoke? Like, if they turned and, yeeted it directly into their face, cool. But this was an over-the-shoulder toss, right? And so I'm like, do we have proof beyond a reasonable doubt here? Because that's our standard, that they actually intended this bottle to hit that person, right? Or were they just hoping that they lose the bottle and the person stops chasing them to go after the bottle?
Well, I have a war story. I got a good story. Pick me.
Go for
I remember
it.
when I was doing trials too, we had a case where a guy was, he was a drug addict, and he was going through cars for change. They open the car, and that becomes a burglary of a conveyance, a third-degree felony. And the guy so he's looking for change, he's grabbing the change, and the owner of the car comes up and grabs him and says, "Hey man, get out of my car." And he pushes the guy and runs. So now it's a burglary with a battery. So it's a first-degree felony, and it's like, come on, this was a battery and a third-degree felony burglary of a conveyance. It was not a burglary with a battery. He pushed the guy to get away. He was trying to run. He wasn't a violent guy. And he was one of the nicest clients. I remember it because he was such a nice guy in jail. And he'd been through the system. He'd been a drug addict, and he's been through jails. And the best I could do for him was 8 years in prison.
Mm-hmm.
And it was like, I thought,
that's hard. That's hard.
That's ridiculous. And I was fighting for him, and he was like, "No, Mr. Gosney, I know you're fighting for me, and I know that's the best you can do." And he was so nice and so kind to me, and I felt bad because I had to deliver him this bad news that that's the best I could do. Because if we'd fought it, he was facing 15 years in prison. So we took
Can I add a perspective to this?
Sure,
Yeah,
let's hear it,
absolutely.
man. I love
Yeah.
it.
So, okay. So a lot of my cases are alleged violent felonies, right? Like someone died, or, someone was
Yeah.
killed, or, someone was assaulted very seriously, like something very bad, happened. And in some of the cases, it's like, oh, my client, they've got the wrong guy here, or the wrong girl. And some of them, it's not. That's not what it is. There's something else going on, right? Or I have no defense. So this is a home truth that I have to say to people. Yes, especially I think it's a very valid question. How could you represent those people? Listen, if this person genuinely did this horrible thing, like the most horrible crime that you could speak of, right? They still have rights under the Constitution. We don't throw people in the stocks. We don't summarily execute people. We give them due process, right? And if I phone it in because I am so disgusted by what they're alleged to have done, then I have violated their due process rights, and there's a check
Yeah.
above me that can overturn their conviction because I phoned it in. I committed ineffective assistance of counsel. And then the family member of the decedent or the person who was sexually assaulted or physically assaulted, they have to sit through another trial again. They have to be subject to cross-examination again. They have to sit in the courtroom and see their loved one's body displayed on a screen riddled with bullets because I didn't do my job in representing them. And so I take it very, very seriously that someone has to be on that side next to that person, because under the Sixth Amendment, they have the right to vigorous, zealous advocacy. And it is my honor to sit on that side to provide that advocacy. And if the prosecutor is doing everything that they're supposed to do, then the truth will win out. The person will be convicted. If my guy is super guilty of this horrendous crime, the jury's going to figure it out. But if for some reason the prosecutor has violated my client's rights, that is all of our rights, right? And then they should not violate my client's rights, or the police should not violate my client's rights, so that I'm not there to point it out. And if I violate my client's rights, the case is coming back. So that to me,
Yeah.
it's an honor to uphold that system. That's just the way I see it.
Well, can
Well,
I
people-
plug something, because people in the chat here
Oh.
are talking a lot about us advocating for the guilty. Yeah, like this one here, Joseph DiMartino, and he says we defend the guilty because that's the client pill, innocent clients. Because a lot of these issues I put on my book, Death Penalty Debates, net positive or net negative. Go to stevegosney.com, and if you're interested in this, because a lot of these, and Natalie does capital, right? You do murder charges.
Yes,
And-
but there's no capital punishment in my states. It's life, but yeah.
Bless you. Well, we have death penalty. Florida's
I
ground zero
know.
for death penalty.
I know.
And a lot of these questions I address, because one of the things I try to do is steel man both sides of the argument and give you the power to decide for yourself. So a lot of these questions that that people are having, I discuss, because I understand where you're coming from. But I remember I have one of our great public defenders, one of the best defense attorneys I have ever been around, bar none, is Miss Rosemary Peoples. I shout out to you. She's one of our lead capital trial attorneys. And I remember she had this terrible case with horrific facts. And she was so kind, and I'm looking at you, Helpline. She was so kind and gentle with the victims, but her job was to advocate for her client and to present mitigation evidence to try to get him something less than the maximum sentence, because that is her job. And she could not have been more kind and more gentle with the way she presented it. But that's her role. Her role is to provide mitigation. But people think that when you're talking mitigation, you are disrespecting the victim. But so you can't say two things at once. And the role of that defense attorney is to say the mitigation. Yes, they had these problems. Yes, they had drugs. Yes, they had. There's reasons why this happened, and somebody has to deliver that message. And you can't say, I feel sympathy for the victim. At the same time, you're saying, and my client has these mitigation factors. And I remember, like, the whole courtroom was very, I thought, unfair with my favorite defense attorney, because they were expecting the undoable from the role. Her job is to advocate for that client. And she was doing it in the best way possible. I talk about that case in Death Penalty Debates. So please go to stevegosney.com and get your book and decide for yourself.
I just did. I just went to stevegosney.com and got my book on death penalty debates, because even though I don't have,
I'll sign it.
Thank you. Please sign that for me. That would be great. Because even though I don't have there's no death penalty in my state. It's the same type of case. Life in prison is a serious consequence.
Same arguments apply.
Yeah.
And it's a difficult, these are the hardest cases to deal with. And I hate doing death penalty cases because they're the facts are hard, and so it's not an easy thing to deal with. But my job is clear. My job is to advocate, and my job is to represent this client that's been given to me. Nobody else is there. And what you said, Natalie, was just exactly right. And that is, by defending these people's rights, we are defending your rights. Like, you say, well, should this guy's a murderer. Let this gunshot evidence in. Let this matching stuff in, this junk science in, because we all know he's guilty, right? But by doing that, now all of a sudden, everybody's got this gunshot evidence coming in. And then you get innocent people that are swept up in this net of injustice. So it needs to go out. This guy, I don't care about this guy, Abdullah, or whatever his name is, right? I care about the justice of the science that's being presented to juries.
Absolutely right. It's for all of us.
Especially with search issues. Like, you can be as innocent as possible, but the reason why the police aren't stopping you to look in your trunk is because they lose cases when they do. Because otherwise, it used to happen in Canada, but Canada's actually very new to the game of people having rights. The Charter of Rights is like from the 80s. So before that, the way you'd get a remedy was to sue the cop. And so what you'd get is a cop who thinks that you might have something in your house, kicks in your front door, has a look around your house, and it's like, hey, you had no grounds to look in my house. And you could sue him for the cost of the door. And so that doesn't end up actually protecting anybody's rights. Like, the cops are just like, okay, the police will pay, like the police force will pay for the door, so long as I don't do too many of them. And it's just, the only thing that actually controls that is they lose cases. But I also want to address this comment that we've got here talking about, the guilty is the client pool. Truly innocent clients are like unicorns. I thought that when I went into criminal defense, I encountered a lot more truly innocent people than I ever thought I would.
Oh, and man, yeah.
I would love to be a situation where every case I run is one where it's like, all right, they're going to get a conviction because the police did everything right and they've got the evidence and my client did it.
Another
I could lose all day and no problem.
Another thing people need to realize is that, people, the jargon you hear is this person was got off on a technicality.
That gets on my nerves.
You heard it, right?
Oh,
I would say that never happens. Never happens. What happens is people get convicted on technicalities all the time.
The definition they use of technicalities,
right?
Things that are technicalities,
right?
You have rights is a technicality.
Right.
You didn't do it is a technicality. They can't prove it is a technicality.
Right.
I saw a court case where they said this guy got off on a technicality after the prosecutor was unable to prove that the guy who was accused of a murder had been at the murder scene. And I'm like, that's not a technicality. That's like, you can't actually show he was involved.
Right. Like the guy was acting in self-defense. That's a technicality.
The Constitution is a technicality to some people. Oh, he got off just because the police kicked in his door for no reason and then found the girl chained up inside. I know you don't feel good that this guy got off, but they're not allowed to kick in people's doors for no reason. They're just not allowed to do that, And so it's like, it's not a technicality. It's the Constitution.
Well, and, when we look at, I guess to bring it back to this case, they're talking about on cross-examination of Mr. McVeigh, their expert here. He answered that he could not identify the least number of matching individual characteristics that he'd ever used to make an identification, declining to say even whether it may have been as low as 2 shared characteristics. That's not great, right? Because 2 things sounds like coincidence.
Exactly.
Well,
Like-
let's talk about, we just had a case. I'll give you another example. Just a case about, it was a not guilty, but the kind of case that went to a jury. We had a guy, we represent people that are poor, who don't have a lot of resources, are not in the upper tiers of society, right? So they're living on the streets. And we got a guy who was trespassed. And I talked with a homeless guy once near my office, and he was like, look around, where am I not trespassing? Because every place around he's trespassing, right? Well, there was a technicality that the trespass warrant was like stale. And so the cop arrested him on this stale trespass. Well, we knocked that out because it was stale. But he also, when he was being handcuffed, he gets hit in the genitals and kicks out of a reaction. So he gets charged with violence, resisting arrest with violence, right? See, Natalie knows these cases.
Yeah.
And so they took it to trial, even though the basis for the arrest was invalid.
That is so common.
Yeah, it does. And this happens all the time. I had
a guy who was charged because the police officer said my client struck him and caused a big bruise on the officer's forehead. And so I asked, like, at trial, it was like, how did he strike you? Well, our heads impacted. I said, okay. Who moved their head? And he said, well, I was using my head to engage him with an impact control strike or something along those lines.
Yes, he escorted him to the ground.
You headbutted him.
The cop headbutted this guy and then charged him with assault peace officer because he got a bruise in the process.
Well, I had another case.
Oh my God.
A witness shows up at a scene of a fight, and she's yelling at the other people in the fight. The cop says, "You need to leave. You need to leave." So she starts walking away, but she's still mouthing. And then so he yells at the person, "Stop." And she keeps going. And so he arrests her for obstruction because he didn't obey a lawful order. Well, which one was it? Was it to leave or to stop? And that was, so to me, that's a conviction on a technicality. And that was upheld on appeal, PCA. Oh. In fact, I was thinking about doing a series on my Rumble channels of all the most, what's the right word? You know what I'm saying? Cases that I should have won, right? Because there's so many of these. People don't realize these are, to me, that's a technicality. Cop says you need to leave, and the person leaves, and then they say stop. So if they kept leaving, they are violating the stop order. And if they stop, then they're violating the don't leave order, right? So you can't win that one.
Even as simple as put your hands in the air, get down on the ground. Those, unless you're a yogi, those two actions do not go together. Okay?
Remember the guy in Las Vegas that got shot?
Yes.
He would say, get down on the ground, get down. He's like trying to comply and do all these impossible maneuvers, and he gets shot with an AR by some amped up cop in the Las Vegas hotel. This is, these things have real world consequences.
Absolutely.
There was a video that I watched where a bunch of officers swarmed this guy, and they're like, like get down, and he's this mentally ill guy, and he just goes like, fuck you, and the officers just drill him. He gets shot something like 60 times because
my God,
they're like mag dumping on him with ARs, and I'm going. And I mean, I say he gets shot like 60 times. You got to think there's a whole bunch of cops mag dumping an AR. So we're talking about police levels of accuracy here. But like he just gets
they're like stormtroopers. They're like stormtroopers with the accuracy.
I had a guy get shot at 100 times by 2 guys with ARs, and they didn't get hit once.
Good for
him. I helped doing some consulting on a file where so this officer mag dumps and completely misses somebody at about 7 feet of range. And they're like, how does this happen? I'm like, I'm going to bet. I haven't seen the file yet, but I've just got to bet. Was the first shot right next to the cop's foot? And he's like, yep. I'm like, okay, here's what happened. Officer draws gun and just starts firing out of panic. And they're actually still lifting the gun, and then they're firing, and recoil is climbing their arm because they've never done this before. And he's like, yeah, that's that's the pattern. They basically just like bullets like walking up and just missed this person because of like it went under and then went over this person who's sitting in a car. And I'm going, yep, that's police accuracy for you. So
Right.
We've had, yeah, and you've probably seen the ones where the police put their knees into the back of the leg, and that creates an involuntary reaction. Then they yell out, "Stop resisting," because they're trained to influence the witnesses. That when the person's flopping around because they're in pain because that knee is in the back of their leg and they're flopping around, and everybody says, "Oh, well, that guy's resisting." So all the witnesses and they stop resisting, as they're beating you with a baton. It's and I'll say, it's not all are like this, but we see so many like this that it's like that, you do get a little jaded.
Yeah.
And convictions on technicalities are much more common than people getting off on a technicality.
Police get trained as well to shout things like "stop resisting" because it will actually shape the memories of the witnesses. They'll remember that the officer was yelling "stop resisting," and then their brain fills in that gap, and now they remember that the witness or that the person was resisting because that's what the officer was yelling.
Right.
That's why the ubiquity of body cameras is, I don't, some people that are advocates, it's no secret here that I'm a more left-leaning person, but we got more body cameras, like what progressives were asking for. And now people on the progressive side are saying things like, oh, it's not doing enough. Excuse me, as someone on the ground actually dealing with these, body cameras are indispensable. There's a big difference between what happened with our motions to suppress before body cameras were on all the officers versus after. And I've been here for both of those eras. And when the judge can see for themselves or the jury can see for themselves, the officer yelling, "Stop resisting," while they're wailing on someone. And, it's just like, okay, well, I'm sorry. I can't find that he resisted arrest. And so I don't think that you had a valid reason to do the things that you did afterwards,
Natalie, you were singing my song. And, 90%, 95% of the cops are really good guys. And sometimes these body cams really help us with our clients because they'll say stuff like, well, he didn't read me his rights. Right. And then so I'm like, okay, well, let's play the video body cam where the cop's reading it from the card and gives you the card. Right. Now, sometimes I've actually caught where the cop doesn't read from the card and blows it completely. And that's great evidence, too. But that's rare. That's the outsider case. Most of the time, it really helps us with our clients because they lie to us. And it helps like, okay, well, let's see that. Let's see what the video says.
Let's cut this down to what the case is about. Right. I had one where the guy's like, I wasn't there. I'm like, well, they've got you on video. He's like, those videos are terrible. You can't see anything. I'm like, here's your facial tattoo. And he's like, oh. And I'm like, yeah. But
no, I love the body cams, and there was a lot of debate about this. But as a public defender, it helps clarify. It's more evidence. It sorts out what actually went on, what the cases are. It helps us with because see, this is another secret that people don't know. The public defenders make the system run. We're the ones dealing with these clients. We're the ones telling them what their options are. We're the ones holding their hands and saying, you don't have a case. You need to take the plea because it's the best option. And the prosecutors have no clue. They just think they can sit up there and bully people around when we're the ones making these happen. I love it. They hate us until we're off the case and the guy's pro se. Then they beg. Then they say, oh, no, you got the best public defender here. They're so great. And, it's like, well, wait a second. You want to deal with my guy? You go right ahead. Public defender, we're off the case. And remember the Darrell Brooks case? That public defender was like, oh, we're out of the case. Bye. They're out. Like they were sick of dealing with that guy.
Steve, you are dropping so many knowledge bombs right now that probably things I haven't even thought to say on my own channel. Number one, about these body camera. Listen, the police like them too. Okay, because you get the public defender with that body camera showing your client doing XYZ. We're not going to trial. Okay,
Yeah.
this is what it shows you doing right here. This is what the surveillance shows you doing. This is what the ring camera shows you doing. All this extra video, it really makes a lot more cases resolved short of trial
Right.
than used to. And then you get on top of that with the whole like, yeah, you can hate us all you want, but go ahead and deal with it. You don't know what we're dealing with behind closed doors. You have no idea.
Right.
You go ahead and deal with that guy on your own, unfettered, with no one there as the buffer to tell him or her, look, this is a plea that you need to take because you're going down, right? It's going to be a very uncomfortable day for you dealing with this person in a pro se trial. So yeah, those are 2 points I never really think to make, but it's absolutely true.
Yeah, and well, it's funny because like in your clients too, they think they're like, well, I'm going to fire you. I'm like, great, please
Yeah.
do. Let me help. Here's the form, right? I feel like I'm out of here. They don't realize that, like, we're doing our jobs. And in fact, you're a public, you know what you're doing, and I can tell it. You're a good public defender, and I love you, baby. And one of the things that people don't realize, we go and sit with our clients, hold their hands, and we tell them the God's honest truth. I remember this one guy. He was telling me this BS story that sounded great with all his jailhouse lawyers, but I'm like, if you tell a jury that, you will go away forever. And it's like, and I have to tell him honestly because I'm the only one telling him honestly. His buddies back there are lying to him and just saying, yeah, that's a great defense, right?
Oh, jailhouse lawyer, yeah.
Yeah.
Oh, jailhouse lawyer is like, we're referring to the people who are in prison who will talk up a great game about like, oh, this is what you got to do and this is what you got to say and this, and they're never good at it. And I like this, like, oh, this guy in here, he knows so much. And he says we got to do this and that. And I said, where'd you meet him? Well, he's in prison with me. Cool. How'd it work out for him? All this knowledge he's got. Oh, yeah, he's in prison, right? Maybe listen to a guy who's not in prison.
Right. Like, there's, you're going to listen to the guy that's in there with you, right? It's so silly. But there is that chest pump. But my job is to tell them the flat, honest truth. And people say, well, how can you deal with these people? They're violent, they're stupid, or they're on drugs or whatever. But I'm like, look, you treat them with respect as human beings, and you are 100% honest with them. And that gets you so far. You're not in their world. You're there to protect them. It's like if somebody coming to you with cancer. They've got a big cancer on the side of their neck, right? And it's going to kill them. Well, I might be able to save your life. So I'm not going to say, well, you don't have cancer, right? That's how I'm going to say, look, you got cancer. You might have a 50-50 shot here, but we can chop that thing off. And we've got these remedies. It may not work, but my job is to heal and to hopefully preserve life.
That is such a good analogy. Like, that's really good. Maybe I'll use that with a client someday because sometimes,
yes, I've begged clients. I remember one client, we got him on we did 3 trials with him. And after the second trial got reversed on appeal. Thank you, Steve. But we had a nerd trial and I begged him to take the plea offer. It was 15 years in prison. He'd already done 5 and he was going to go down a 3rd time. And I said, you've got to take the 15 years. And I spent a half day in the jail begging him. And I remember he gave me a big hug at the end and said, Gosney, I love you. You're a good man. And I know you believe, but I want another trial. And we took it 3rd time and he went away to prison. He got life in prison. And, it's painful, but, you do your best and not all of them can you save.
And it's their decision too, under the law. It's their decision if they want to go to trial or not, if they want to testify or not. But, I know that I recognize on the other side, from the client experience, that having a public defender can sometimes be like a problematic situation. I never leave that unacknowledged because I know that, we're not like a private attorney who has maybe 10 active cases or something like that, or maybe 15 active cases for the whole year or something. That's not how it is for us. We have lots and lots of cases. And so that can color the client experience where you don't feel like it's such a one-on-one experience. But I swear to God, we care so much about you. We do not, when we're giving you advice, it's not because we're getting some type of kickback or something. They don't pay us anything.
Oh,
Well,
That's
and
why
in fact,
we're,
like, see, Natalie, you're a trench lawyer, right?
right.
A lot of the, the clients, see, I'm kind of, when I get in court, I found that I'm quite the scorched earth public defender, and I fight.
Same.
My clients love me.
Yes.
But I will tell you, honestly, that is not the most effective public defender. That's why I just dive in for trials, because I don't negotiate well with prosecutors. And, and the problem is that clients loved it when you fight, because they think that you're betraying them behind the scenes if you're friendly with the prosecutor.
Oh,
But a lot of effective public defenders know how to schmooze. My buddy Mac, who passed away recently, was really a good schmoozer. And he's a pro golfer, and he used to go, come on, you're going to give me the deal. And he used to get the best deals for his clients. And it's like, and I used to do his trials because I would fight like the devil at the trial, but they didn't respect him. But he got them such good deals because he knew how to schmooze.
He was saving their lives.
You also have to be willing to go to trial, because a lot of prosecutors will have a position when they're not looking at running a trial that's really strict. And then their position starts to get a little softer when they're looking at, like, oh, I got to put in all this work. But I had a client, he was super pissed. I got him a deal that ended up with him not getting a criminal record. He just had to do some probation, a little bit of community service, like whatever else. But he's walking out and he sees me in the cafeteria just chatting with the prosecutor. And he calls me up and he is pissed. Like, this guy is angry. And he's like, you sold me down the river, like, blah, blah, blah. You're, and I'm like, do you think you get a deal like that spares you a criminal record, spares you jail time, if I am always an ass to the prosecution? Like, if this guy hates me, he'll sell, he'll
that's
go.
why Mac and I used to tag team, because he would negotiate. And if he could fail, then he's like, well, I'm going to bring Gosney in to try the case, and he's an asshole, and you're going to, and so and I'd come in there and pound on the trial. And so we were a good team, because I love trying cases, but I didn't like dealing with the negotiation part. So, pairing up, and that's something we can do in the public defender's office, is utilize the best skills out of our people. I love working for the PD.
What you guys are making me think of is kind of the way that you're describing this is me thinking of my maturity through being an attorney. So I came in I'm still a very idealistic person. It's one of my I'm very, very, very idealistic. And I'm like, no, this is unjust. This is wrong. And like, it make me go crazy. And, but I was that on 100 when I came in as a public defender. And so my client wasn't pleading guilty to nothing, right? And the prosecutor is the enemy. I'm not talking to you, and my maturity was learning to balance that. I'm a trial dog. I died in the paint. I love to try cases. It's the reason I do this job. I can't do anything else. I know it now, because I tried and I was just like, there's not enough trials in this. I need to try more cases. So I love to do trials, but guess what?
Trials are fun.
Oh, they're so much fun. And I'm going to go so hard in your trial. I'm going to have the jury sitting there like, wait, did this guy do it? I mean, I know I just saw him do it on video, but did this guy do it? But ultimately, I'm going to give them a great song and dance. I'm going to do the best that I can with what I've got. But I'm not going to prison. I don't face life in prison. He does. So it's a hubris thing on my part, where it's like, I love the performance. I love the cross-examination. I love the prep. I love, catching the state missing a piece of evidence that I caught on to. I love all of that, but there's a risk. I don't know these 12 people. Right. These 12 people don't know me. And this is their first time ever seeing my client. And they could convict this guy and put him in prison for the rest of his life. And so it's caused me to check myself and be like, no, you need to go talk to this prosecutor and tell them, look, I think that your case may have some weaknesses, or this is the mitigating things about my client. Can you please come down from 50 years to 20 years. That's really what some of my cases are looking like these days. But either way, or can, you have these weaknesses. Is it possible we can do some type of deferred agreement or something like that? And that used to burn me to do that. But I had to remember that my client is a person. They have a life they want to get back to. And so when we present a plea offer to you, it's not because we're trying to sell you out. It's because we're trying to save your life. And we genuinely believe that there's so much risk in trial. Maybe you don't want to take that risk.
Well, and we've seen people like my client who turned down 15 years and got life. I've seen that happen too much. I had a guy who I represented on appeal that turned down probation for 5 years on a third-degree felony on the day before trial, went to trial and got life. And people don't realize how dangerous it can be to go to trial. So I am, in deference too. Obviously, there's varying quality levels of different public defenders. We have some of the best in the world, and we also have people that are government workers who are mailing it in, right? And so you do have to. It's hard to assess that who you've got. But so many of and I know in our office, we have a great office. We really strive to be a team and to give the best. And, not everybody's happy with us. We get a lot of unhappy clients, right? They write me letters all the time.
I had a guy, he was I was like, I got you a great deal. You're looking at 6 months. It's going to suck, but you'll get through it. And, you'll probably do 2/3 where I am, he was going to be looking at 2/3. I'm like, you'll be out in 4 months. He basically said, you're an ass. You don't know what you're doing, blah, blah, blah. Fired me, hired somebody who he paid a lot more money than he paid me. I can tell you that. And took it to trial and got 5 years. And I was like, how's that feeling? It's like, you said I was an ass because I said you're looking at a conviction and you're looking at a much harsher sentence, but I was right,
Right. And this is not just us like tooting our own horn or anything. It's just the experience of, I had something just like that happen, Ian, where this guy, this was a while ago. This might be maybe 10 years ago at this point now. But the guy is on video in a grocery store, stuffing meat up his shirt and stealing the meat and walking out of the
such a popular means of doing things.
Yeah, just stuffed it right up his shirt and walked out. And it was like $100 worth of meat. He walked in with a flat stomach. He walked out looking like he was pregnant or something. And I said, sir, this video is damning, And he said, I don't believe you. And walked out of my office. He was very angry, fired me, hired private counsel, went to trial. And, I didn't pay any attention after he fired me. I have a lot more cases. So I'm in the jail visiting other clients, and I pass him in the jail. And he said, I should have listened to you. I paid a lot of money to get convicted because his plea was to time served, no jail time. And he went to trial and then went to jail. And I was just like, why didn't you listen to me? And he was just like, I don't know. I just felt like if I paid somebody, I would get a better chance. And I was just like,
and
okay, I'm sorry.
The other sad thing is that there are some lawyers out there who will tell you anything you want to hear, so long as you're paying them. And, they'll say, I guarantee you're going to win at trial. And nobody nobody reasonable guarantees anything. I have had to run appeals on obvious points. And I mean, sure, maybe the prosecution consents to the appeal, but you still have to pay for the appeal. You still have to go through it. I've had judges invent evidence in their head where they're like, oh, well, this person said this. And it's like, well, when we look at the record, that doesn't actually.
Well, actually, I just did an oral argument that I posted on my Rumble channel involving that very thing, a judge imagining something that was not in the record. It was he was a sex offender. He wasn't supposed to dress up as a Halloween costume that appealed to children. Well, there was no evidence, zero evidence that the costume appealed to children. He was dressed up, but it was a devil costume, and there was no photograph, and there was no testimony that it appealed to children. And the appeal to children was a required element.
Weird. I've never heard of anything like this before. I'm fascinated.
Who puts that condition on somebody? That's a weird condition.
It's a sex offender condition, and the idea is to have people. It's kind of complex, but he was at work at Denny's, working late, and he had dressed up as a costume to make tips, and they violated him for dressing up in a Halloween costume that appealed to children. And there was zero evidence in the record that the costume that the probation officer testified, oh yeah, he's in a costume, but never said it appealed to children. So that is a necessary condition, and he got 22 years in prison.
Oh my gosh.
Welcome to Florida, man.
And it's like, here's the thing, is that we're not defending sex offenders or anything. We just want the law to be fair. It's like, because it doesn't work when you do things that are draconian and arbitrary and capricious like that, because it won't actually deter future sex offenders. He also got a
$400,000 fine.
Well, he's never going to pay that because he's in prison.
For $50 a day cost of incarceration, which is actually in my other book.
Oh my goodness.
Ideas and Answers in Law. Right here. This very case is in the book regarding $50 a day cost of incarceration is an excessive fine under the Constitution. And we've been working very hard in our office, or I've been thinking about this for really years, trying to challenge this $50 a day cost of incarceration. And the very case I orally argued last week is in Ideas and Answers in Law. It is the case about that it is an excessive fine. There's a case called Bajikikan, I think, out of the U.S. Supreme Court, a Thomas decision, that says, is it excessive and is it a fine? And that was the issue. And that was the issue I orally argued. So hopefully that case is going to come down in Florida. We're looking forward to that.
Whenever you see, people who've been convicted of sex offenses, they get put on these conditions, and the goal that people have is to breach them. And
okay, yeah.
So you see a lot of people who are actually trying to follow their conditions. I had a guy who quite literally, he went off to live in the forest, and he just went and set up in a little camp to stay away from everybody. He basically was like, screw it, I can't get in trouble if I live in the middle of nowhere. Well, they determined that to get to and from his cabin, he had to pass through a little sliver. The road cuts across this little sliver about 4 or 5 kilometers wide of a park, like a national park. And this park is like forest, right? It's not like a playground or something like that. It was just, but they said he can't go into parks, and therefore, and so they breach him on this. And I'm going, why? What are we actually getting? Shouldn't we be okay with this guy going off to live in the forest? Aren't we happy with that?
That's the thing, is do you want to make the sentence life in prison for that offense? Okay, that's what you want to do, right? That you want to make. But if that's not what it is, then you're not deterring people from committing a crime. If it's like, well, any random thing can get me locked up, so I don't care. I don't care what. That's what
society.
Yeah, it's like if it becomes arbitrary, then people don't get deterred. If it's like, okay, if you really want to deter people, you set things that they can follow that actually protects victims. Okay, you don't go anywhere near schools. You don't do this. You don't do that. And the people that get convicted of that and then do exactly what they're supposed to do, that makes sense to prevent anything bad from happening in the future and protecting victims, that should be enough. And if you're going outside of that and just trying to find reasons to just lock people back up, you're no longer doing a deterrence. You're just being draconian and arbitrary, and that makes people give up, and I think puts more people in danger. I'm going to sign off now, Ian.
Natalie,
great having you.
Wonderful being with you.
Thank you. It was really nice meeting you.
Runkle to we got to do the conclusion, because I love the conclusion of this case.
Yes, we'll get to the conclusion. I just want to make sure everybody, Natalie Lawyer Chick, go check out her channel. Great commentary, fantastic. Tomorrow, if you join on the membership, she's doing the Hot Ones challenge,
and you'll be there. You'll be there, right?
Be there. Okay. I've got my old set from, it's like a season before yours.
Okay.
So we'll go through sauce for sauce. I'll fire up some wings fun. And we'll do it.
I'm excited. Good night, everybody.
Hey, good to see you, Natalie.
All right. Nice meeting you, Steve. Bye.
I just wanted to highlight this as well. When they're matching matching test for test, this is, I think, so damning. So damning. So they've eliminated, they're not counting inconclusive. So this is better for the testers. When looking at non-matching bullets, did they come to the same conclusion about non-matching bullets? It was 49% of the time. Worse slightly than a coin toss. And that's the innocence. That's the innocence condition that we're looking at here, right? It was not your gun that fired the fatal shot. And investigators can only match it 50-50.
Well, and we're going back to the gunshot matching thing. It's basically just not reliable science. It is opinion testimony that is subject to a lot of error and is not subject to peer review or testing or invalidity. So to allow that type of evidence to go before a jury with the imprimatur or the stamp of the court and the stamp of the state to say this is a match, it's a lie. It's a lie to the jury, and we should not allow the prosecutors or the state to lie to juries.
Yeah. Let me find the conclusion here.
The conclusion is great, and this is the model that this is what I've been advocating for as long as I've been on Rumble, and whenever I've been screaming this from the towers before any internet stuff. But I'm so happy the court did it in such a way that's perfect. So this is the way every state should do it.
So, conclusion, based on the evidence presented at the hearings, we hold that the circuit court did not abuse its discretion in ruling that Mr. McVeigh could testify about firearm identification generally, his examination of the bullet and bullet fragments found at the crime scene, his comparison of that evidence to bullets known to have been fired from the Taurus revolver, and whether the patterns and markings on the crime scene bullets are consistent or inconsistent with the patterns and markings on the known bullets. However, the circuit court should not have permitted the state's expert witness to opine without qualification that the crime scene bullets were fired from Mr. Aberqua's firearm. Because the court's error was not harmless beyond a reasonable doubt, we will therefore reverse the circuit court's ruling on Mr. Aberqua's motion in limine, vacate Mr. Aberqua's convictions, and remand for a new trial. I was kind of stunned that they actually tried to argue that this was a harmless error. Like, hey,
well, and this is another one that our appellate judges screw this up too. About they give the wrong standard for harmless and error analysis. But again, Maryland does it right here, and that is
the state must show beyond a reasonable doubt that the error in no way influenced the verdict.
Yes, we deal with this a lot as a burden shift in the appellate level. A lot of times they say, well, he's guilty, and the state has the burden to prove it did not affect the verdict, and that's the proper standard. At least that's the standard in Florida, and obviously this is the same. And sometimes this gets muddled in Florida. They don't apply the correct harmless error standard. This is sort of a catch-all. There's always going to be a harmlessness analysis attached to most decisions. Most things, there's a harmlessness piece in an appellate rule. So they're just appending that to the end. That's all.
Yeah, it's the harmlessness thing is frustrating, because if it was harmless, like if it doesn't actually affect the decision, why was the state calling it? Like, basically, to me, that standard is this would have been irrelevant evidence.
Right. And it's funny how they argue like, oh, it's no big deal at all. They fight like the Dickens to get it in. And then and then once it's in, it's like, oh, that's just a meaningless thing. It's like that we usually deal with that when it's prior crimes or similar fact evidence. They want to bring in some other crime that's not related to it to show that our client is a bad guy, right? Yeah. And when they're fighting for it, it's like the devil's own, right? I mean, they say, oh, we got to get this in. It's so important. And then once they get it in, it gets blasted in front of the jury that our guy's such a bad guy. Then they minimize it and say, oh, well, wasn't a feature of the trial and it's harmless. So,
and for the chat's benefit, like similar fact evidence can be relevant. Like, let's say there's a serial killer who always murders people with like some unusual weapon like this thing, and leaves behind like a pink rose at every scene, and has like clown or basketball player size feet, and also like always showers in the shower at their place, and always does like all of these different things, right? And so you've got these 10 killings that all match that same pattern, but you have no evidence as to who it was at any of these particular things, except that on the 11th killing, you find the guy at the scene, right? Like the cops just happened to be there and they catch the guy. Similar fact evidence would be to say, listen, all of these killings are so unique that they had to have been done by the same person, and it has to be this guy because we found him doing one of them. But prosecutors like to, fudge similar fact evidence. So they'll be like, oh, this was so unique because this guy broke into a car by punching out the lock with a screwdriver. And then once inside, he dismantled the, the steering column in order to access the ignition. And it's like, those are features of almost every car theft.
Right. Well, we've actually, sadly, you were enunciating the old standard, which was the fingerprint kind of like, this is the signature move of this, and it's similar fact evidence in
this
it.
is what they're doing in Canada. So.
Well, but we have completely abandoned that in Florida.
Oh,
it's
God,
basically
no.
they open the door wide open. There is no, it takes a minimal amount of similarity to show. It does not have to be a signature. It's sad, but they basically slime our clients all the time with similar as a very broad brush. It's not similar at all. And it's another one of those loosening of controls on evidence because they show the person's bad enough. Like, I mean, we represent clients. You say, well, they did all these burglaries before, right? And he's being accused of this new burglary. Well, he's like, look, I didn't do that burglary. And maybe he didn't. He confesses to all these other ones. He's like, but I didn't do this one. And they're like, what do you mean you didn't do that one? They pound on him. So they bring him, they make him look like a bad guy, which he is. He's a criminal. He's a burglar, whatever. But he didn't actually do this one. And if you looked at it in isolation, you would know that they don't have the proof, but they slime them and then the juries convict. So sadly, that's that's the way it is in Florida right now.
The other thing that the reason why you can't typically just tender somebody's criminal convictions is that there's used to be common practice. And what they would do is there's like, hey, we've got a murder. Somebody killed this woman and we have no evidence. So we'll pull out this bad guy and we'll say, like, we'll put him in front of a jury and we'll say, look at this guy. And he's probably somebody who's got like a big facial scar and, whatever else. And they'll say, on this day, he beat this person for no reason. And on this day, he committed a robbery. And on this day, and the jury will convict that person based on that string of he's a really bad guy. And the police think he did it, even with no evidence that connects him to the actual crime.
And it makes sense. You want to put the bad guys away, but we really want to put the guilty away. Guilty proven beyond a reasonable doubt with admissible evidence. And it's very human nature. It's very human nature, and it's understandable. But it's our job to advocate for our clients again and get people straight with the law. And we hope that jurors are reasonable and follow the law. But that's why we got to keep out deceptive stuff like this firearm matching evidence. Because if it gets in front of the jury's going to believe it.
And that's the thing is you can end up with situations where if you let them put in bad evidence, then anybody can be convicted, right?
Right.
And like as a person who doesn't get into trouble, like I don't do anything criminal, I would like to imagine that I'm only going to get convicted if I change my mind about that, decide to do something criminal. But if they can just tender bad evidence, then that becomes a problem, right? It's I just covered a case. It's a self-defense case in Canada. Although they rejected self-defense, they had a firearm expert testify that you can only fire a pump action shotgun every 3 to 5 seconds.
No, come on.
Yeah, that was their testimony. And like, I did a video, like in my video, I've got a pump action shotgun. You can't do this on a live, but you can do it in a pre-recorded. And like, I'm not firing it because I'm doing it in this room, but I'm like, trigger, rack shotgun, trigger, sip of Coke, set Coke, like, and that's in 5 seconds. But the thing is that this massively colors the situation, because their theory is that this was an intentional killing of this guy he finds breaking into his truck, and he says that this guy is turning and he thinks he has a weapon. Well, just think about this: if you fire the shotgun twice, like bang bang, that's like, oh, I'm reacting to this emergent situation. But if you fire the shotgun bang bang, that's you shot this guy, you're seeing him go down, and then you're taking an intentional shot to finish him off.
Right.
And I'm like, this firearm expert testified to something under oath that is complete horseshit.
Wow.
So I mean, and that firearm expert's going to go on and testify in more trials.
Right. And it's, yes. Well, and it's kind of like in death penalty debates, something that, I try to be fair to both sides. I mean, I'm very anti-death penalty, but I steel man. I used to be pro death penalty. And so I try not to short shrift. I listen to both sides. And one of those things that people need to understand about the death penalty when they're supporting it is that it's a system. So it's not like people will bring up an example of this guy that they think should get the death penalty, right? And there's a myriad of examples of that. But you don't get that choice. What you do is you empower the prosecutor's office to make that choice. And then what happens is it's a system. So the system, yes, it's used in cases of these extreme cases, but it's also used against the marginal cases. And in the marginal cases, those are the ones that may be actually innocent that get put on death row. And in Florida, we're number one in the country for exonerating people off death row. So, for every 3 people in Florida that are actually executed, there's one person that's been exonerated off death row, which is incredible amounts of error. And the thing is that, when you really think about it, and this is why if you really want to think deeply on the issue, get this book and study and understand both sides as deeply as you can. And then it doesn't push. I put my opinion at the end of the book, but it's designed so that you can analyze for yourself all the sides and all the deep understanding that I've put in through all these years of practicing in this area so that you can decide for yourself. And one of those things you got to understand is it's a system, and that you are empowering prosecutors to make these calls and use it as a weapon against people that may be actually innocent, as well as the actually guilty in the very bad cases.
The other thing to think about is just how many people plead guilty because the alternative is the death penalty. So they never get the death penalty. But, if you're sitting there and they say, listen, if you plead guilty today, we'll give you 5 years. But if you run this, we're going to make it a death penalty case. Or we'll give you 10 years or 20 years. You're sitting there going, I have a chance of seeing my grandkids if I take this deal. Lots of people take deals that...
let's take this and put this into a real context. People are very familiar with the Rittenhouse trial.
Yeah,
the Rittenhouse trial could have been a death penalty case because he killed multiple people, right?
Yeah.
So, and just the fact that he was shooting multiple people, and now we understand that followed it closely that was a self-defense case. But if he had lost that, if the jury had gone against him, he could have gotten the death penalty.
Yep.
So you are empowering prosecutors like this Binger basically to use this weapon against the citizenry.
It's this is also a reason why in Canada the courts have been skeptical of mandatory minimum sentences, and they say, listen, this is a weapon. There was actually something. The court struck down a mandatory minimum sentence for possession of a handgun or like a restricted or prohibited firearm, which is handguns, machine guns, various guns that they've banned without a license and with ammunition. But the thing is, it was actually a weird sort of mandatory minimum, because it was a mandatory minimum if the Crown decided to proceed with the case in a particular way. And one of the things the court pointed out was, they said, how much negotiating power does that give them? If they can say, listen, we'll ask for 3 months, but if you want to go to trial, we're going to trigger this 3-year mandatory minimum. And the court was like, this is a concern. And they said, oh, there's no evidence that that's ever been that's ever been an issue. And I like where the court came in. They said, basically, the history of criminal justice is that if it is possible for something to be abused, it will be. So we don't accept that argument.
We're seeing that more and more in our country, and it's sad. I think people are beginning to wake up to the overpowered prosecutor's office and the abuse of the criminal justice system. And and I think people are a little more receptive now when we're making these kind of statements, that it's not just, we're not the enemy. We're here to protect the rights of the citizenry and trying to bring life to our Constitution and bring life to a system of justice that, if functioning properly, is a good system. But when abused, it can be warped into a tyrannical system. So I'm on one ways, that's the bright side of the tyrannical prosecutions that we're seeing, is that people are a little bit woken up for the issues that we deal with every day.
I think more and more people, because there's more and more interest in in the law, and especially in criminal law, more and more people are going, wait a minute, this isn't what I signed up for. This isn't what I thought our system was about.
Well, and it's amazing, because I've only been doing this YouTube Rumble thing for like the last year, maybe, right? I mean, this is a new deep dive. And I will say, one of the things that in all honesty, has surprised me, and I guess I'm a little naive and a little idealistic, is that the prosecutor's office problems that I've perceived locally are throughout the country. When we're looking at it, I do this thing where I grade the prosecutors and the judges and the defense team after every trial that I cover. And it's about half the prosecutors I'm grading very low because they cheat and they're playing dirty. And that is not the way it should be. I want us to have, just like I want us to have great police, I want us to have great prosecutors, great defense teams. We should strive for that ideal. Natalie was saying she's an idealist, but you got to aim for the ideal so that we're all a little bit better. Because if we just think we just accept human nature, we're all going to devolve into tyranny and into the bottom. So we should all be a little bit idealistic and expect a little better from all the participants.
Yeah, it's and I've had some great experiences with prosecutors. I've had some terrible experiences, but by and large, I feel like the Canadian experience, or at least the one I've had, is better than the impression I get from the US experience. Because I've had a lot of prosecutors do things like midway through, like I had one where the judge actually said, and I'm going to convict, and the prosecutor said, "No, I'm directing a stay." I thought about it. I don't think that this is a case that where I don't think there's proof beyond a reasonable doubt. I came to that conclusion while you were off thinking about it. I'm killing this case. And that takes tremendous courage, because the prosecutor could have just been like, no big deal, right?
Well, and there are, I really, those are the good prosecutors. Those are good judges. And that's what we want. That's the ideal. We need to get my wife is not from this country, right? She's from the Philippines. And when she came here, she has a lot more common sense. They're a little more in tune with sort of reality in the Philippines. And when she came here, she said her observation for America was she says America, no good idea is no good idea. What was it? We take our good ideas to the extreme, right? Every good idea we take to the extreme so that it becomes a bad idea, right? It's like, well, there's a moderate here. There's a middle ground. Be reasonable. Look at things reasonably.
Yeah.
Canadians are kind of a little more reasonable. We tend to be so ideologically possessed, and the jurors bring that into the courtroom. The prosecutors bring that into the courtroom because they're the good guys, right? They're gonna, and people come in, they've got all these ideas in their mind, and they've decided the case before they've heard any evidence. We need to get away from that and start being more reasonable and rational and in touch with our duties as citizens.
I mean, Canada's got its own issues. I think that there are some things we do better, like not electing judges, I think is a better choice, and various other things, but nowhere is perfect. And the criminal justice system is basically a disaster holding itself together with spit and tape and baling wire, but it's better than it could be, I guess, is really what we come down to. So, yeah.
And it also becomes the dumping ground for all of our societal failings. So, we get a lot of people who have mental illness that get dumped into the criminal justice system. We have people with, obviously drug addiction gets dumped. We got people with family, a lot of people that have that are grown up with broken families, and they end up in the criminal justice system. So we end up basically locking up people that are societal failings. And I'm not getting all bleeding heart on this because I'm not on that side. But the fact is that the expanded criminal justice system is where we dump a lot of our societal failures.
Oh, it's straight up. And a lot of people in the criminal justice system would be better dealt with some other way.
Well, and it's sad because the mental illness is something we really fail on. And we get clients that are obviously incompetent, low IQ, and it's a tough challenge. In fact, I don't know if you've heard Jordan Peterson. You're a Canadian, right? A great Canadian, Jordan Peterson. He talks about this in that, like, there's like 10% of the population that have, I think, under an 80 IQ. Basically, they're not even acceptable to be ground or cannon fodder in the army, right? They can't exist. And we have a legitimate responsibility to those. And I think somebody coming from the more conservative side, we need to be able to wrestle with that challenge of what do you do with these people that really can't exist in this high octane, high, information society that we have. What happens to people? I mean, do we just throw them all in prison? Is that a humane thing to do? Is that a Christian thing to do? So,
the other thing I point out to people is they're like, oh, well, I don't want to, be whatever to addicts. I'm a fiscal conservative. I don't want to pay for this. And I go, cool. I'm a fiscal conservative as well. I would rather just give them the drugs.
Or the big mistake that we made back, and everybody blames Reagan, but it was really a confluence of the ACLU, the left, and the fiscal conservatives that shut down a lot of the mental institutions, because they said, on the one hand, people are free to be living on the street without drugs and mentally ill, as long as they're not a harm to themselves or others. And then, of course, the conservatives were saying, you mean we can shut down all these institutions and save all this money on mental health? So let's agree. So they both agreed, and they shut down the mental, and they dumped all these people into the streets. And to me, you're imprisoned in your mind if you're mentally ill and homeless on the streets. You may not be a danger to yourself, but you're not living a full flowering of a free life.
I always point out this like wedge, and what I mean by that is that we've got. So let's say you've got a guy who's got a what is in now like a $250 a day heroin addiction, but that's $250 a day on the streets. And to get that $250, he then has to steal stuff that's probably worth about $750 because he's getting he does not get full price for what he's stealing, and he's probably causing like $5,000 in damage in the process, because they'll break into a car to steal a $5 bill that's sitting on the seat,
Right.
and it's $300 of damage to the window and so forth. But I'm like, we also look at what the government pays for that same amount of drugs, and it's probably about 25 cents. That is, and then I just go like, okay, we know this guy's got an addiction. He's going to be out there committing these crimes while that's going on. We can help the guy with his addiction, but in the meantime, maybe we could just stop that $5,000 worth of damage that's these guys doing every day. And I see that as the fiscally conservative viewpoint on that.
Right. Well, same with my case I told about the 19 years in prison for stealing a can of spray paint. As a fiscal conservative, it offends me. That person is occupying a prison slot. We're supporting that person for 19 years. When, what is the harm? I mean, if I was there, I'd like, here's a $10 for the spray paint or whatever it was, right? I mean, we're going to lock somebody up for 19 years for that. Think about the societal cost of incarcerating somebody for that time of period.
Oh, it's thousands of dollars a week. It's incredibly expensive keeping people in places they don't want to be, and where they're unhappy, because they will leave if they can, right? And they'll get into fights, they'll get into violence. I see situations like, I had a file where this guy, he was hungry. He just goes into a store. He steals a sandwich, and the thing is that the guy who owns the store wasn't the guy who saw it and called it in. It was another customer sees it and calls it in, because the guy who owns the store was actually a very devout Sikh, and Sikhs, part of the philosophy is you feed the hungry. And so when the police were there, he's like, can I just give him the sandwich? Like, I would like to just give him the sandwich. And I'm going, why is this guy getting prosecuted when the guy who owns the place would just rather give him the sandwich than send him to jail? Like, just...
and in fact, like, one of my rules when I deal with a homeless person, they approach me, I will always feed them, but I don't give them cash. So I say, somebody says they're hungry, I'll take them to the McDonald's or say, buy them a sandwich or buy them some food. As a Christian, I believe it's my duty to feed the poor and feed the hungry. But most of the time, they aren't interested in the food. They just want the cash for drugs, right? But I've bought many a people a sandwich. Half the time, they walk away and they don't really want the sandwich. But
it's tough, though. If you go in, a lot of homeless people get screwed with, for one thing. So, and a lot of restaurants won't let you bring a homeless person in. Like, and it's weird. It'll be like, there's a guy there and you're like, oh, I'm buying this sandwich. They're like, are you buying it for that guy? Yes. Oh, well, we're not selling it.
Really running into, and it's drugs, mental illness. It's all of these pathologies. All these pathologies are getting dumped into the streets. And, our society, we have big problems. We're great at sending rockets to the moon and orbiting satellites and building great things and military machines. And we're great at making money. We have a lot of strengths in our society. But one of them is not relationships and compassion and humanity. We suffer in those areas, and those pathologies are getting projected into our cities and into our society through the criminal justice system. We're sort of at the bleeding edge of a lot of that.
Yeah, it's I see a lot of situations where it's just like, even if you don't, like, if you're just a hard money person, the money angle on that is away from, prosecution. If you've got somebody who's stealing sandwiches, it's cheaper to feed them than it is to jail them, because when you jail them, you have to feed them anyway.
Well, and many of these people, I'm a little skeptical when people say they're hungry, because our church, which I give to my church, that's my charity, we have a food bank, and and there's a lot of mechanisms for getting food, and like you said, but Why people steal these things, I don't know. I mean, we talked about deterrence earlier, and I get another point that I make in this book. I must say, now that I'm thinking about it, I'm here on your channel. It actually has a lot of applicability to things besides death penalty. So it's a very short, it's a very focused book, but one of them about deterrence. And Natalie had brought up about deterrence, right? If you do this, it won't be deterrent. But deterrence relies on a rational actor.
Yeah.
Most of our cases are not rational.
Oh,
Go ahead.
I took a law and economics class, and there was an entire section on criminal law, and so I'm sure I was annoying as hell to my prof, because I was just like, "Are you kidding me?" Because they're like, "Okay, let's start with our assumptions. Assumption 1, everyone is rational. Assumption 2 is that they act to maximize their interests. And assumption 3 is that they have perfect information." And I'm like, why don't we just assume a magic unicorn that solves our problems? It's exactly as true. And, I'm like, so what if these assumptions aren't true? They're like, well, to the degree that they're not true, our model won't work. Like, but the degree is 0. Like, none of this is true.
Yeah, can I indulge? This is so nice. You're so nice, Aaron. I appreciate you having me on. And here I am pushing my books on your channel. But
I haven't gotten to the book. I want to read the book real badly.
You need to read it, because here's a lack of deterrence, and this is one of the arguments against the death penalty. Right? Murderers do not think they will be caught. As a practitioner of criminal law dealing with thousands of defendants, my observation is that most murderous criminals do not think rationally. They do not think they will be caught, or perhaps better stated, they do not think. Further, most murders are driven by drugs, mental illness, passion, irrationality, disrespect, territoriality, primal instinct, or a combination of these things. None of these motivations are subject to specific deterrence.
Even when you look at the guys who plan things out, like when it's a planned out, what are they planning? They're not planning, and here's where I get caught and I do 20 years. They're thinking, and then I'll move the body here and I'll get away with it. That's their plan.
My wife loves these murder shows. I can't watch them. These English shows where it's like the butler, and they have a poison, and it's a 2-part poison, and there's a candle that burns in the thing, and they, it's all this crazy. I'm like, that is so, I just can't even watch them. They're so nuts.
I mean, when you actually look at even like the planned out killings, they're not that great. Like the plan is typically
very rarely.
I go to my ex-wife's house, I bludgeon her with an axe handle, I roll her up in a carpet, blood gets everywhere. I load her into my truck, blood gets everywhere in the truck. It soaks through that. I drive her out to the woods. I don't even bury it, because digging a hole actually is really, really hard. Or maybe I start and then I get tired, and and then she's found by a hiker, and then I go back to her place, and I am seen buying, garbage bags and bleach and whatever. They see me taking those things to her place where I have no reason to be. And it's like all their effort to try to not get caught. When you actually think about it, it's so stupid, right? All of these plans are never going to work, but they have these plans, and then they it's really a way that they just delude themselves into thinking that they're going to get away with it. And and
like I said, there's a lot of stupidity too.
Yeah.
I mean, it's a lot of these people are very dumb. Now, I will say that our office, Eileen Warnos, we represented Eileen Warnos.
That's fascinating.
Yeah, we have a lot of serial killers in Daytona Beach. We had, the list. Gerald Stano, we represented. I don't know if you know Gerald Stano.
Don't think I've heard of that one.
I think he killed 60 people.
That's impressive in its own way.
Impressive, yeah, great. Actually, we've had, this is funny. This is not funny. Funny, not funny. We've had 4 murders in the last 2 years within eyesight of my office. In fact, one of my office mates witnessed a murder at his lunch break. right down the street. Like he was going to the 7-Eleven, and it was fascinating because it really shook him up. But he was there, and there was this woman, this man chasing this woman, right? And he's yelling, and they're arguing, and she's running from him, and she got shot dead. And and she falls down, and he had to watch her bleed out. It was horrific. And the guy's there, and the cops show up, and he's like, "There's the guy right there. He did it." Points at this guy that was chasing her, right? He didn't see that there was actually another person that was there and was aiming at the pursuer guy and shot at him and hit her and killed her.
Oh, geez.
And it shows you like how the mind works. And we have disqualified ourselves off this case, by the way, because of our, we have an office mate who's a witness. And when he was there, he's like, "That's the guy right there." But it wasn't. There was this dispute between this new boyfriend and the other boyfriend, and he's coming there with a gun, and he shot. It's a mess. But it was incredible about the memory, because our mind doesn't want to have unresolved questions as a matter of biological evolution, because we have to piece things together, and our mind will create connections to things. So here's this guy chasing her. She's running, and he shot her, right? But he didn't see the second shooter, the second guy. So he's putting these two things together and saying, "I saw him shoot her." It was amazing watching his memory. And then it's a fascinating story anyway. We had a double homicide right down the street from my office. We've had so much stuff. Yeah, I'm smiling. This is gallows humor. This is what we do. We're dealing with these murders.
I've never been a witness on a murder. I was a witness on a guy who had a whole bunch of weapons, but he committed an assault with a weapon. Basically, he gets into this minor car accident, and then he pops out of his car, grabs a baton, and goes after the other guy. And it was funny because the police called me, and they're like, "Hey, what did you see?" And I told them what I saw, and they're like, "Okay, that matches up with everything we heard, but we're not calling you as a witness." And I said, "Why?" And they said, "You got the colors of the vehicles wrong." And so everything, like in terms of what happened, I got right. The colors of the vehicles, way off. And they're like, "Also, we don't need your testimony because when we got there, we searched the guy's trunk looking for the baton, and they had a bunch of machine guns." And they're like, we're going with the machine guns, and we don't even care about the assault with the baton anymore. So I was like, fair. The other, after that, some years later, I reported a guy who was drunk driving. He was drunk driving to the point where he was like all over the road. And because I remembered that problem that I had with my memory the last time, I'm sitting there and I'm telling the 911 driver, like the 911 operator, everything. And she's like, "Sir, we already have a car." I'm like, "I am talking because you're recording. You don't need to respond to this. I am just putting it on your tape." And she's like, "Oh." I'm like, "Yeah, I'm going to keep following this guy, and I'm just going to narrate exactly what's happening." And the prosecutor was like, "That was the best thing ever, because we know we've got you on the tape." And it's just like, that's what happened. He's like, "Even if you go in, you're like, I don't remember anything, but you can confirm that you were narrating it accurately at the time. That's enough." Like, we got the conviction there. So the guy ended up pleading guilty rather than running a trial. So, and I'm not normally a big call the police guy, but this guy was going to kill somebody. He was all over the road.
Well, and people think that, I'm not against police. I love police. I love good cops. We need good cops. And that's when I rant and rave against bad cops, good cops should also be against bad cops, right?
My line is that good cops deserve to work with other good cops.
Right.
And they don't deserve bad cops, right? So I actually had an officer who I grilled the hell out of him and his partner, and he held up on stand. His partner did not. And afterwards, the guy who held up was like, "I just wanted to say thank you." And I'm like, "Why?" He's like, because that guy kind of sucks, and he needed somebody to like embarrass the hell out of him. He's like, I watched that happen, because he'd already testified, so he was free to go wherever. He's like, I watched that happen. That was exactly what he needed, like just to get humiliated in there. And I'm like, so you don't care that my client walked? He's like, hell no, we'll get him next time.
Right.
Like, it's like, all right, we'll, and that's the thing is, I've had prosecutors say this. It's like, well, your client got away with this theft. You got one of two outcomes here. Outcome one, he never commits another theft, and that's great.
Right.
Outcome two is he does, and we bust him, and we'll get him then. Like, it'll work out in the end.
Well, that's a good cop right there.
Yep. Oh, I good cops make my life difficult, but I love seeing them. Like, and that's the other thing is the cop who scares me in the trial isn't the bad cop. The bad cop I can usually, like, that's the guy I'm gonna try to break on cross-examination. I've got a strategy, like, here's where I know you're lying, here's where I think I can catch you in that lie. Good cops are a freaking terror.
Right.
Like,
See, you're making another great point. And that is that, defense attorneys, if you stick to the truth, there's very little you can do on cross, right?
Oh,
and so the thing is when you're dealing with that, it's like, and this is with any witness, the witness sticks with the truth. It's like, this is what I said, this is what I saw, this is what I heard, and that's it.
Yeah.
I was there. That's what I saw. That's what I did. I wrote it down. And, but it's like when somebody, what happens, cops, and you see the bad cops, usually they don't just flat out lie. Usually what they do is they like to put their finger on the scale of justice because they know your client did it. And so they're going to put on this little advocacy hat, right? They're going to put on their advocacy hat, and they're going to say, well, and they're going to embellish, and they're going to add details, and they're going to try to sneak stuff in that they shouldn't be sneaking in because you open the door. And they're going to be doing this dirty stuff, creating error in the case, instead of trusting that the system, they're not just the only person. There's a team of people that are witnesses and evidence custodians. There's a prosecutor that's directing the trial, right? But they think they've got to get in all this stuff and make the jury know this it's stuff that shouldn't be admissible, right? And they blurt it out.
Yeah, the other thing bad cops will do a lot is fudge on they'll fudge on the search. And so they'll search before they had the grounds to. And then later at trial, they've got to justify that. So now they're bullshitting.
Right.
And so, this is a situation where you've got like the videotape. And so you can see like, oh yeah, you went looking, you say that the gun was in plain sight, right? Oh yeah, no, the reason why I searched his car is because when I looked through his window, I saw the gun. I'm like, okay, cool. You found the gun in the back seat. And the guy's like, yes, I did. Here's the video. Why do you start by searching the passenger seat, the glove compartment? I'm like, you see that there's a gun in the back seat. Isn't that the first thing you go for? Well, no, I thought I'd look at the glove compartment. It's like, that's bullshit. We both know that's bullshit. Because if you saw there was a gun, you go for the gun first, right? That is your starting point. Then you look around for other stuff. It's like, it wasn't in plain sight. You just searched his car and then you found the gun. You got lucky. You weren't good, and and the thing is that when cops are getting lucky like that, it means that they're searching a lot of other people's cars and it just never ends up in front of a court.
Well, and you get what you see oftentimes is you see jargon. So you get cops that say, I saw a furtive movement. That's one, they pick that up. Well, do you ever use the term furtive movement in your everyday language? That's language that came out of some case, and they heard that if somebody makes a furtive movement, that gives them a right to search. And so I'm like, okay, cop, make the furtive movement. And it's like, all right. I mean, it's something that's so ridiculous. You put them under the microscope and it's a garbage statement, but they'll justify what they're doing by these jargon statements.
I've had officers be unable to define the words that they're using. And they're like, well, I don't know the dictionary definition. I'm like, just give me a casual definition. Like, what does it mean? Like, what's a synonym for it? And they're like,
I had a case of, well, when I was prosecutor, I guess I can talk. I always have to think if I can, what I can talk about, what I can't, because I was a prosecutor 6 years, and I've been doing defense work for what, 13 years? I don't know. But so I have to put it through the minor. But this was as a prosecutor, so I can talk about this one. The guy was it was a baby case. It was a very bad infant thrown down on the floor case, right?
ooh,
And the cops had the guy, they put it, and the guy was saying he dropped the baby. He dropped the baby, but the injuries to the baby were such that it couldn't have been from one drop, right? There were multiple skull fractures,
right,
such that it couldn't have happened the way he said it. But the guy in his statement to police was, he called the cops, which is good for him, but he called the cops when the baby was injured. And they came out and he says to them, well, I dropped the baby, right? Because obviously he's panicked and doesn't know what to do. And so what the cops did is they had him and they said, okay, so tell us what happened. Oh, I dropped it. So they gave him a doll and they said, now show us how this drop occurred.
Ooh.
And so he's like, and it was so obviously BS, right? Because he hadn't thought that far ahead. He hadn't actually thought. And this is the truth comes out when you say, okay, show me exactly. I actually had a cop I had him demonstrate for me in a defense state. It was a DUI. I said, now show me what you had him do and what he did. And it was such BS that he hadn't done that. He hadn't actually demonstrated it. So it's like, oh, now I've got to come up with some lie. I've got to build on my lie by demonstrating something that I said that I hadn't thought through. Now I've got to go the extra step, just like the guy dropping the, he'd never actually thought through what he was saying. And when he demonstrated, it showed you the lie. Same thing with a cop imagining, things that happened that didn't happen.
I had a cop who said that, when he read the guy's rights, he didn't use his notebook, which has the rights, like it has it printed out, like what they should say in the notebook. So he's like, no, I did it from memory. And I said, okay, is it possible you got it wrong? He's like, no, I'm really good at this. I always do it perfectly. I said, cool, read me my rights. And he went, I said, you just arrested me. Read me my rights. And he went, well, I'm not ready. I said, you said you got it memorized. You said you can do it perfectly. Go.
Well, that's wonderful. That's great.
And the prosecutor
strategy, because he might know it.
Well, the thing is, he's just testified he knows it perfectly. So if he does it perfectly, all right, I can still make, hay on that or try to get something in there. But the thing is if he says he's done it perfectly, it's probably that's what the judge is going to believe until this guy starts clowning. And the prosecutor tries to object to this. He's like, I don't see the relevance. I'm like, he just said he's got it memorized. He always does it perfectly. And the judge is like, can you do it? And the officer says, no. He says, Mr. Runkle, I think we're good. Like, I don't think you need to make him go through the process. He just said that he can't do it today.
That's great. That's okay. A great, man, you've given me a tip. I'm going to pass that tip along to our trial division. That's cool.
It's always risk. Like there is some risk.
High risk.
If the guy does it perfectly.
I have a similar high risk strategy I pulled as a prosecutor once. You got, you shouldn't ask the question that you don't know the answer to.
Yeah.
Yeah.
The other one that was funny is this guy says, I always do this. Like I always do this as a matter of course. And I say, okay, would you agree that you always button up your pants? Like you always zip up your pants? And he says, yes. I'm like, and you never forget. And this is a great question because there is no right answer to it.
Okay, let me hear it. This is great.
Well, because if you say that you always zip up your pants, you're lying. Everybody has forgotten their fly down at some point.
Well, you always check it, don't you? You're always like, I may not have forgotten, but I'm definitely checking because I'm worried about it.
But, the guy says, I always do it. I never forget, which is already BS, right? And whereas if the guy says, okay, I do forget, I'm like, so you'll agree it's possible that you make mistakes even on routine habitual things, I guess. But But
These
in
are
this case,
great.
he's like,
Yeah. I'll bet you're great on cross. This is
it really depends. There's some places where you can be really good. It's harder when you are in like a difficult cross. So I can't say that I'm always fantastic. But this guy,
people
he
don't know.
says,
Defense attorneys are generally much better cross examiners.
oh, because we do it all the time. We are
Yes,
actually
because that's
worse
what we do,
at
right?
direct
We're
exam.
showing the problems with the testimony through cross examination. We do that all the time. And usually prosecutors are very bad at cross.
But the funny thing on this guy, so he's like, I always do up your zipper. And I look and I say, always?
Okay.
And he looks down and I said, you had to check. It's not always. You had to check. He's like, okay, I guess not always. I'm like, so you'll agree that routine things.
Well, that's wonderful.
He's like, yeah, you always on like the best place to put somebody on cross is that situation where there isn't a right answer, where either, and you can only get there when somebody's already bullshitted themselves into something. Because if they're just telling the truth, you're never going to be able to get them into that place where it's both answers are bad. But
usually it comes when someone's sticking their neck out.
Yeah, it's when somebody's overreached and when they're trying to make their testimony too good.
Right.
That's the point where you can be like,
and this is why we talk about good cops and good prosecutors is stick to the facts. You're a witness. You're not an advocate, Mr. Cop. And you're a fair witness and people will believe you. Don't stick your neck out. Don't testify outside the bounds of what you know and what you do.
Well, and this is especially true here in Canada, where the judge can allow in the evidence on a rights violation. So I've had officers, just like good cops, absolutely screw me by going in and just being like, yeah, I screwed up. I had an officer who's just like, yep, no, I made this mistake. And I was hoping he was going to come in and bullshit about his mistake, because then I can hammer him on that. And it looks so much worse if he tries to bullshit it in court, because now it looks like a big deal. Because if it wasn't a big deal, why would he be bullshitting about it? But when this guy just comes in and he's like, yeah, no, I screwed up. I jumped the gun on this. The judge is just going to fall over himself to admit that evidence. And I'm just like, I hate this.
The family
good cop beat me.
The family IT dude asks a question here. He says, in general, why would a defense attorney be better at cross than a prosecutor?
We do them much more often.
Right. And I will say there's a chapter in my first book, Ideas and Answers in Law, that talks about prosecutorial misconduct, but it's also the chapter's actually I used to train prosecutors when I was in the prosecutor. I used to train cops when I was in the prosecutor's office and train them how to do direct. And the reason is because being a prosecutor is relatively easy. Your case is basically made.
And then what happened?
Right. But it's basically you've got a cop and you've got witnesses and you've got evidence, and your job is to present that to the jury. So you go to the cop and just say, or the witness, and say, so tell the jury what happened. And then the person talks until they object and say, objection, narrative. And then you just lead them down, say, okay, well, what happened next? And what happened next? It's all direct examination. And you lay out the case, you present the evidence, you get it in, and then that's it. Your job is not to dissect witnesses. You are presenting evidence that you believe should be believed in a fair way to the jury, right? Whereas a defense attorney, your job is to poke holes and to discredit and to create reasonable doubt. So generally, and prosecutors a lot of time are hired right out of law school. So they haven't done the cross. They don't understand it. It's so easy to do direct. And that's most of their case anyway.
Cross is hard.
Cross is hard. Absolutely.
The other thing is like, let's sort of run through a sample, ordinary, boring case. Somebody walks into a supermarket, is seen on camera, but the cameras are way up high and the cameras are poor quality. That camera has to be brought in through like the loss prevention officer who's watching it or whoever. That loss prevention officer sees this guy being suspicious, like throwing stakes down his pants. They, contact another loss prevention officer. And there's also the cashier at the front desk. All of these people get a vision of this guy. They're waiting for this guy to leave so that they can arrest him. And then when the guy leaves, he hauls ass and escapes. And they find a guy who matches that description 6 blocks away, but they don't find the meat because the guy knew he was being chased and ditched it. My client, I can't put him up on the stand because what he would say if he got up on the stand is, yeah, I stole some meat and like I was going to resell it. That's a bad, I can't put that up on the stand. But the prosecutor still has to prove their case. And that's because we expect the prosecution to be good, not lucky. Right. Because if they just arrested the guy with the same color of shirt and the same color of hair, then that's, then they're just lucky if it's not the right guy. They have to be able to prove it beyond a reasonable doubt. So they bring in the first person, the LPO who's watching over the video. I have to cross-examine this guy. I have to start poking some holes as to his, and get him to agree. Well, this video is kind of fuzzy, isn't it? Are you sure? It's a black and white video. You say it's a red shirt. You didn't know that at the time. It's a black and white video. I guess I didn't know that. You're right. I heard that later. Okay, cool. The next guy, the next guy actually follows this person in the store. And I'm like, but you didn't want to be in front of him, right? Well, because if you're in front of him, he's going to see you and he might make you. And then he's like, yeah, I guess I was following him from behind. Okay, so you didn't get his face. No, I didn't see his face. Okay, so what you really noticed was red shirt, gray hair. Yeah, okay. And you'll agree that there's more than one person with red shirt and gray hair. Yeah, okay. Person at the front. I saw him run past. He was running at that point. Yeah? Yeah. So this guy's pretty much a blur, right? Well, I think, because you pointed to my client just a moment ago, but you don't know for sure. I guess not. Okay. I've had to cross-examine 3 people. Prosecution has cross-examined 0 people because I'm not calling any evidence.
Right.
And this is super common as trials go. Defense is cross-examining all the time. Prosecution almost.
And it's amazing. I've seen prosecutors screw up cross-examination so many times. Generally, most prosecutors are not good at cross. And it's because it is a skill. It's something you have to work at. You have to think through. It's almost a mindset. And I don't think the prosecutorial mindset really lends itself to that. I wonder, I always wonder, if I went back over to the other side, if I was, how my experience as a public defender and a defense attorney would acquit me in the courtroom, right?
The more experience the prosecutor, the more practice they'll have with cross-examination, because it's more likely that the accused testifies, the more serious the charge is in some ways. Sex assaults, you'll get a lot of testimony from the accused. Hey, yes, we slept together, but it was consensual, and I have to testify to that. Self-defense violence, you are often going to be testifying in a self-defense case. Just to be like, why'd you shoot him? I was scared for my life. Cool.
Well, and this is, I am, the older I get and the older, longer tooth I get, the more I really like to put on my client, if at all possible. I like to have them testify because I think the juries really want to hear from them. However, people don't realize one of the reasons we don't put them on, not only is because they might have a prior record, which is a big reason, but another big reason is they are not lawyers. They are not good on their feet. They don't like speaking. They fumble around. They look guilty because they're not artful with their words. And they just can't, they can get tricked by a smart prosecutor who knows how to trip them up and knows how to get them squirming on the stand. And they just don't acquit themselves well on the stand. Just for that reason alone,
they're often of
put under that microscope.
They're often of well below average intelligence.
Right.
Often addicts. often mentally ill,
Right.
and it can be. And the thing is that the jury and even like judges and so forth, they set their standard of honest witness on the basis of the cops they see. But the problem is that cops are professional witnesses.
Right.
They go in and they testify
See, I
all the
used to
time.
teach police when I was in the prosecutor's office. I used to teach cops how to testify, and they don't like testifying. That's like not outside. That's outside their wheelhouse, right? They want to chase bad guys and write report. They don't like write reports.
Some cops love court.
Some do, but a lot of them don't.
Um,
Oh yeah, no, and a lot of them really don't like defense lawyers.
Right.
Like,
oh right. Well, it's fun. I remember one thing. This cop came in and he was being deposed by the defense team, and I was prosecuting. And he comes in my office before the deposition, and he's like, "Well, what do you want me to say?" And I looked at him. I'm like, "Well, tell the truth." and he, oh, don't I need to be aware of anything? I said, "Yeah, go there, answer the questions. You were there, right? Answer what you know, right? Don't be afraid to say you don't know." And say the truth. And it was like, oh, okay. But a lot of prosecutors feed their cops, here's what I want you to say. And I'm very much against that. I used to as a prosecutor, I'd throw a lot of people up there without talking to them at all. I'm like, you tell the story because you were there. I wasn't. I'm not telling you what to say.
I mean, I'll talk to my clients, but I can't tell them what to say other than tell the truth. But I can say, like, hey, in this portion, I got you tripped up on this cross-examination. And usually a lot of my trial prep is you have to be honest.
Right.
And, because they're like, well, my entire life's on the line. I'm like, yeah, that's why you have to be honest in ways that hurt. Because the places where I catch you on when I do a practice cross are all the places you tried to bullshit your story to be better. And I've had clients who got up there and testified to all the bad things that they've done, and it was beautiful. But I also had a client, and whenever I'm sort of telling the war stories, I file off all the serial numbers so that you can't tell where it originates from. But this is a fight, like a bar fight with two people, and bar fights are typically two people are beefing with each other. Like there's a woman nearby that they're both kind of trying to impress. And eventually, like, one person throws the first punch and then it turns into a fight, right? And they're really hard to prosecute because it's the question of who threw that first punch. You can have a bar full of witnesses and they'll split 50-50 as to who threw that first punch.
Well, it's even looking at football. Like, you use a football analogy. The guy that gets flagged is the guy that retaliates, right? So one football player pushes the other, and then the other guy pushes him back, and the guy that pushed back is the one that gets flagged because the ref didn't see the first push, right?
But so we're going through all this, and I'm like, you tell the truth, because he's and the truth was him being a jackass that whole night. And so I'm like, we'll be fine.
And this is the thing. I mean, people ask, like, well, how do you do these defense? I love closing arguments. And one of them things is like, tell the truth to the jury. Yes, my client, he was not the most likable guy there. But he deserves, or he has the right to defend himself when he gets attacked physically. He's a loudmouth, right? But that doesn't mean you get to hit him in the face. And it doesn't mean he doesn't get a chance to hit back if he's getting attacked. Right. So in those honesty appeals, there's so many stories.
But the problem is my client gets up on the stand and he tells this different story, this new story. And it has him as the most sainted angel. He walks in, there's harps and singing, and there's a beam of light over him the whole time. And he's behaving perfectly. And this other guy, for some unfathomable reason, is being, and the thing is this matches none of the rest of the testimony. So now it's this question of, is it self-defense? Oh, right. We see this guy is lying. Why would he lie? He must have thrown the first punch.
Right.
It guarantees his conviction because he, and I'm just like,
Well, and in fact, as a prosecutor, I remember we used to say more people would go down for lying than they would for actually doing the crime.
Oh yeah.
And it's amazing. Some people, it amazes me, and I work real hard. Well, see, I haven't promoted all my books. I also have my book, Prepare, The Handbook for Individual Freedom, forward by Nick Rekieta. But this book is more of a philosophical book about how to live your life. It's more of a self-assessment. But in this, one of the things, I struggle very hard with is to always try to be truthful and honest. And it's a struggle because sometimes it's hard to know what the truth is. And it always shocks me. And dealing with clients and law and prosecutors and cops, everybody, people will lie even when it's against their interest.
Oh,
I don't understand this. It's like you tell the truth and it will benefit you, but they would rather lie. I don't understand this. Explain this to me, Mr. Runkle. Ian, I am at your mercies now.
Sometimes, people just sometimes find it really difficult to tell the truth, especially in situations where the truth is embarrassing. So, you'll get less so now, but you used to get cases of like people getting in, like men in fights with other men who they're in a relationship with. And you'd get situations where they're just like bending over backwards to make this into something other than what it is. And I'm like, you two were in a hotel room and like, how does this happen? Like, and they're just like, and I'm like, just tell me the truth, right?
Just tell the truth. But they'd rather, and it becomes pathology and people lie to themselves. And one of the things there's a part in Prepare here that I talk about how to incorporate this into your life, because what'll happen is we justify our lies, right? And the one that automatically comes up is when the wife says to you, do I look good in this dress? Right? And then, of course, the lie is easy to come back with, right? It's easy to lie. But here, do you want to really lie with your wife, or not lie to your wife? Well, you want to lie with her, but not to her, right? And so, here is my challenge. This is Gosney's self-help. We're moving into Prepare land at this point, but try one day to not lie at all to anybody. Okay.
Oh, you're never going to make it.
No, here's the challenge. And when you fail, you just said, well, you're never going to make it. When you fail, when those times are. Write those times to yourself when the wife asks you, does this dress look, do I look fat in this dress, right? And come up with what was the lie you said, and then think about it and say, okay, how could I have answered this truthfully and still got and done a better job and answered it better?
I will clarify that. I'm pretty sure, because there's so many like little lies that people tell over the course of the day that are just like, hey, how are you feeling? I'm feeling fine. Well, it might be, no, I'm actually hungover and feeling kind of depressed. And, you say I'm feeling fine because you just don't want to burden somebody with your crap. But I've been on like, week-long hunting trips where I talk to nobody. So I'm good on those days.
Well, those are the days. And the thing, this is where it comes to what is lying. I would also say it is not necessarily easy to tell the truth, because discerning the truth is difficult. What is, and there is no absolute truth. And I talk about this in Prepare. That's very philosophical, this book. And we're getting kind of philosophical here late in the stream, but it's a struggle to do the truth. That's why it's so much better to struggle towards the truth, because you will be honest. Your life will be better. It will be happier. You will be more happy with yourself. You'll be proud of who you are. You'll become a better person. You'll become a truthful person. Aristotle said, we are what we do habitually, right? And if we are habitual liars, we are liars. Even if you say, oh, no, I'm truthful except in these situations, right? Well, no, wait a second. What do you do habitually? So it's something I really want people to do. And it makes our society is so filled to the brim with lies. Our media, our corporations, our courtrooms, they're filled with lies. We have to fight back against that as good people. And we got to start with ourselves. And
Well,
that's one of the reasons I wrote this, because this is my personal book. You know how I got into this, right, Ian? Did I
no,
tell you? Okay, because Bronca got me to write the first one. Because he's like, you need, but I kept telling him, like, I really want to write this book about philosophy and my philosophy of life, but it's out there in the netherworld. He's like, Gosney, just write that book of all those articles you wrote. So I was like, okay. So I put this one together with the Andrew Bronca forward. And then
nice.
when this one was successful, it allowed me to write this one. So
Right.
this is my personal philosophy book. And this one is law review articles to practice of law. And then this one is the death penalty debate. So I've got lots of books. So and they're only available for me at stevegosney.com. How about that?
Well, I'm doing something similar in a weird way. I've got my hot sauce that I'm trying to
tell me about the hot sauce, man.
So this one is just, people know I like spicy things. So somebody reached out and is like, hey, a friend of mine is starting a fermenting company. Did you ever want to make a hot sauce? And I went, hell yes. I actually already had made my own hot sauce. And so I made this hot sauce.
Is it one of these blistering hot, or is it a tasty sauce?
It's tasty, but it's also hot.
How hot? Do you have levels of hotness?
So this is about the same as like Bravado Spice Company's black garlic. And I'll just point out that they rate that as 5, but I wouldn't put it in the same category as some of the ultra hots like Da Bomb and that kind of stuff.
What do you put this on? What do you use? What do you use it on? Like,
I eat it on all sorts of things. Like I put a fairly heavy coating on a sandwich just recently, but I have a high spice tolerance. I have known for on occasion doing things like taking a pull of hot sauce midstream, because and if you've been watching, I occasionally just taste a bit of it because it's good stuff. But and I can sort of take a taste of, like, this is the last dab, which is the hottest of the sauces you get on the heatiness. I like hot sauces, but so a lot of people might have to be a little more cautious about this one than I am. So,
but what do you put it on? Like, because what I love to put hot sauce on is greens. I've
never actually tried on greens.
I'm kind of a lightweight on the heat level.
I've never tried it on greens. One of the things I have tried hot sauce on that I actually really kind of like, and everybody thinks I'm weird for it, is vanilla ice cream.
What?
Vanilla ice cream.
What? Repeat. What do you do with vanilla ice cream?
Hot sauce.
I've never heard of such a thing. Explain yourself, Mr. Runkle.
So, there's a sauce. It's like an Indonesian sauce, I believe. It's called sambal ulek, and it's fairly spicy. It's a little more spicy than like sriracha, but it's also got really great flavor. And so when I found that stuff, like, found it in the store, I started calling it universal condiment, as a joke on universal solvent, because I'm like, I'm putting this on everything. And my wife is like, you can't put it on everything. I'm like, try me. We'll bet. I bet it's good on everything. And she said, okay, ice cream. I was like, you're on. So I put some of the hot sauce on the ice cream and sort of stirred it in. It's actually surprisingly good.
I don't know, man. I don't know if I'm that brave.
You've got this mix of like the hot and the cool. So you can actually probably tolerate a hotter sauce in your ice cream than you can tolerate somewhere else, because you're already getting that the cooling effect, but it's actually really pleasant. So I quite like it, but I put it on all sorts of things. Like I'll put it on fish, I'll put it on steak.
People in the chat are saying that they're busting you, saying you drink it right out of the bottle.
I have done that.
Really?
Oh, absolutely. Um, like this is my hot sauce.
I've never seen. Will you demonstrate? I don't want to. Oh,
Cheers.
there you go.
And
where can we get this nefarious hot sauce? And does it ship internationally?
So right now I'm in the process of so the guy who did the ferment, and I gave him sort of a rough recipe. He adapted it a little bit, but because my rough recipe was literally a picture of the stuff I put in my first batch, and he's like, I can work with that. Like I'll keep the same ingredients, I'll keep the same percentages. We'll make a sauce, but he needs to fill out the form for an FDA registration number, because the FDA keeps track of every kitchen that because then that way if I send it to a bunch of people and they die or something, the FDA wants to be able to be like, we're not taking any food from that kitchen anymore. But I mean, I've been consuming enough of it that I don't think it's lethal. But
is there are there peanuts in it? Because I have
no peanuts. So the ingredients, I mean, the ingredients are going to be on the label. First ingredient is fermented habaneros, apple cider vinegar, Thai chilies, shallots, Alberta red peppers, garlic, red Fresno chili, gray salt, chive blossoms. So there's no extracts in it. There's no nothing sort of weird. It's just food mixed with other food kind of thing. And so it's habanero forward. I like habaneros. They're a spicy pepper, but they're a flavorful one. And so yeah, no peanuts, no meat products, so it's vegan. It's gluten free. It's all of the good things. I need to get him to fill out that form so that I've got a number. The U.S. is willing to forgive. There's all sorts of regulatory requirements, like the ingredients section that you have on something. So Canada requires you to include this particular nutrition facts box. The US has a similar nutrition facts box that they require, which is slightly different. But the US is willing to say you don't need a nutrition box at all if you apply for an exception and you also are doing less than $500,000 in business each year. I am not doing $500,000 in business. I have 180 bottles.
Not yet.
So,
someday, we aspire great things. Hey, I've got your Ian fan. Your chat is very nice, by the way. You've got a nice chat.
I try to cultivate a community that I enjoy hanging out with.
Yeah.
Good folks. I mean,
there's something about a hot. It's here. I've got Susan says, if you join Runkle on the Spice Challenge, I will buy all 3 of your books. Now, I'm all for selling books, but I need to always be careful on what I'm agreeing to. So what is the Spice Challenge?
So I can pull that up. Give me a second here. I'll just sort of so we'll look at season 21. So they do this on their YouTube channel. Now their YouTube channel, people keep saying I have to go on their channel, but they're having people who are like famous actors, so there's no way they're taking me. Not with my small YouTube channel, whatever. But it's wings. Each wing that you have is with a different hot sauce, and so the hot one, like,
this is making me hungry, actually.
But each sauce steps up. So the first one is the chili maple at 1600.
Well, so you're talking like real challenge. This is not.
Oh, it's you'll see, like, go onto YouTube, watch watch the Hot Ones challenge.
No. Okay, I'm out. No, I'm sorry. That you're at Susan. You're bless you, but I'm going to have to take advice of Nicholas Starro.
Yeah, I was going to say
lawyer,
you don't
he's
want.
Saying no, and I will say that I used to love hot sauce. In fact, I still love hot sauce, but as I get older, my insides do not like it. So I have to ramp down the heat quite a bit. I thought this was something like I could do right here, but
No, like it starts out at 1,600 Scoville units, which is
Okay,
pretty
no,
mild.
I'm out. I'm tapping out.
Um,
I'm a lightweight. See, I'm a lightweight in all things, in
at,
alcohol.
at number 5, they're up to 50,000 Scoville units. At number 8, they're at 135,000 Scoville units. And then at number 10, they're just at to be announced because they're still waiting. But their number 9 is 500,000 Scovilles.
Oh, man. Can you do this? Do you actually do this?
I did a Hot Ones challenge on my stream, and I got through all of them.
Oh, man.
Rob got through all of them
you do
as well.
have a hot sauce tolerance.
Rob was nearly dying. I was doing much better than Rob was, but I can tell you, the like 2 at the end will mess with you, even if you've got a really high spice tolerance. So
see, and I love spice. I love spicy stuff. I love it hot, but I have to recognize that as I get older, my body cannot tolerate it. It really hurts me on the inside.
If you're going to do anything with like these kinds of ultra hot sauces, one thing I will say is a really, really important thing to do is make sure you have a full stomach. Because if you do them on an empty stomach, it will rip you apart.
Okay. Yeah.
You don't want to be feeling the heat as badly from the inside. So yeah, make sure you eat first. But yeah, no, they some of them are really good. Like when I did it, I actually found some of the hot sauces were really tasty. There was one that was the unique garlic was really good. There was the Los Calientes barbacoa, which is not super hot, but was so tasty. The turmeric bomb was really good. So I'm going to be looking back, or I'm going to be doing one with Natalie Lawyer Chick tomorrow. We're not doing the same season because I don't have that season. So I am going to, I'm just going to do my season, and we'll see how it goes. But
there's a really funny video. I'm going in August. I'm going to go over to Colorado and hang out with Andrew Branca, and we're going to. My son and I are going to go, and we're going to go see the Strongman, the Shaw Classic in Denver. You ever know about Strongman?
No, is it like a strongman competition?
Right, strongman competition.
Oh, that'll be interesting.
It's going to be fun. And one of the funniest videos I've ever seen on the internet is a guy named Brian Shaw, who's 4 times world's strongest man. Who I'm going to go see the Shaw Classic. He's amazing, probably the strongest man to have ever walked the earth. And he does this hot chip, like this chip challenge, like the ghost pepper chip.
The one chip challenge. I've done that.
He does this chip challenge. I think it was the chip challenge. Maybe it was the noodles. There's this like fiery chicken noodle challenge with the other guy named the American Monster with Robert Obrist. So it's him and Robert Obrist, who are both strongmen, doing this hot noodle challenge. It's one of the funniest things I've ever seen. I enjoy it, but see, the reason I'm bringing this up is that I also know enough about myself that I should never participate in such an event. So
know thyself is important life advice, because I've seen people wreck themselves on hot stuff. One of the funniest. So this is hilarious,
and it's not even the intake. Sometimes it's the outflow. You know what I mean?
I don't tend to get that problem as much, but female friend of mine started dating this guy who was very, very much he comes off like he's compensating for something. So he's got that like real small man syndrome where like everything, he's got to be the best at everything. And so I'm at this place that I like, and so I'm like, I would like the the hottest wings. And they're like, okay. Now, I've had their hottest wings before. They're a challenge, but they're good. And they're one of the places that actually has good spices in them. And so the guy's like, I'll have the same thing. I'm like, are you sure, man? Because these are like, they don't mess around here. And he's like, if you can handle it, I'm sure I can handle it. Now, this guy is like much buffer than I am. And I'm like, okay, dude. Okay. Okay. So they bring these wings out. And I'm just going, all right, I'm just going to start eating these things. And I'm enjoying it, but like, I'm wiping my nose is running, because it's hot. Like, you still get some of the physiological responses. He bites into one, and I see his face go like, I have made a terrible mistake. And I'm like, Now, at this point, I've already decided that I don't like this guy. And I've already decided that like my friend deserves better than this guy. So he sort of gets through one wing and sort of sets him down. And I'm like, going for two? And he's like, yeah, man, you know it. I'm like,
yeah.
okay. So I eat one. And then I eat another one as he's sitting there like, I say, hey, man, you're slowing down. And he's like, okay. So I basically drag this guy through this entire plate of wings. And he's like, oh, I'm dying. And so finally, he's eaten all the wings and he gets up and leaves. And she's like, did he pay? And I'm like, I don't think he paid. No. Turned out he hadn't paid. So he just gets up and leaves. And he's like, his eyes are watering, all of this. And she's like,
your ego is driving. See, this is men.
Yeah.
Men have this problem. You see, we have to be manly and, see, I don't have this problem. See, I have no problem admitting I'm a lightweight and I can't handle super hot stuff anymore. I used to, no longer.
And that's the thing is you can enjoy, like, eat what you like. And that's what, like, I'm eating the hot stuff because it's a place I really like their hottest flavor. This guy was eating it just because he's like, I've got to show up this guy. And I could tell he's like, hey, this guy and my girlfriend have been friends for however long. He's competition. I'm like, I am not your competition. I am married.
Yeah.
She's been a friend. Like, we are not dating. That is not happening.
This is such a man. See, women, women and men are different. Let's admit it. And this is one of those things. You don't see women doing this stupidity, right?
But women would have been like, hey, you don't want to eat this.
Right.
And the other one would be like, okay, I trust you on that. No, this guy, he just wanted to, show me up. And it was just like, all right, dude, if that's the way you want to be, like,
that's a great story. See, I haven't heard these. These are great stories. It's one thing about criminal lawyers. We have good stories, right?
Oh, I mean, you've got to, good trial. You
got to be a storyteller, right? In trials, that's part of it, is telling the story.
Yeah. Canada, we do a lot of trials judge alone, but even with a judge,
sure,
the judge wants to hear what happened. And sometimes your theory is just, they don't know what happened either. So, and I've gone in and I've said, hey, my closing submissions are, I would love to be able to tell you what happened in this trial. I can't tell you, but neither can the Crown.
Right.
And the Crown's theory doesn't make any sense. There's holes in it. You've got to acquit because we don't know what happened. But in other situations, they really want to have a competing story. Like, it's not just that my client wasn't the guy who robbed the liquor store. Here's what he was doing, not robbing the liquor store. He was doing this, he was doing that. And if you can't tell that story convincingly, and, you're just relying on the facts, but you have to make them sound correct. And often your client doesn't help you. Even when your client is when your client is dead on truthful, and has videotape of themselves the entire evening, your client will often sound like a liar just because he's a client. So yeah.
Oh, I got to correct Nicholas our Nicholas here, he says, I'm not saying that women are incapable of eating the hottest thing. They are completely at equal odds. I'm just saying that men are
They're
stupid enough.
smarter.
They're smarter because they know. We men are like, I can eat that. Even though we're stupid, we put our ego. See, I really work very hard to understand thyself and not
I
put
feel like,
myself in that situation. But it's the guys who get competitive and put themselves in situations. At least that woman knows that she could go toe to toe, right?
and I can tell you, there is no way I would get through 12 chocolate marugas. I just would not happen. But a lot of guys, if they were up against that woman, would keep trying long past the point where they ought to have stopped. So that is that's the thing, is I feel like a lot fewer women chase that ego
Yes.
into trouble that
Yeah, well, that's what somebody was saying in the comments too about that's why women live longer. Hey, Bubba, watch this, right?
Well, and I mean, you see it in the bar fight scenario where guys
right,
get their
exactly.
ego.
Men, that's what we kill each other over stupid territoriality stuff.
Oh, it's insane.
Yeah.
And I mean, sometimes it's on purpose. Like the guy gets humiliated in the bar, goes out, gets a gun, and shoots the other guy. And sometimes it's by accident, where they get into this stupid, idiotic bar fight, punches this guy in the head, the guy falls backwards and dies because he hits the back of his head on something. And that guy is sitting there going, I really wish I'd never got my ego in, like, let my ego get me into that trouble. Because I can tell you, if you punch somebody and they die, that is going to with your life in the worst ways.
Oh, right. And and it's hard to control violence to the point where you won't break a bone or break a tooth or a jaw, which all of a sudden becomes aggravated battery, and now you're facing felony. It's just a mess. So yeah, try to stay away from violence. But and men are just, I don't know. We have a stupidity gene in us that has to do with territoriality and ego, and I don't quite know what it is. Women have their own evil side, but it's expressed differently. Let's put it that way.
I had a client who was really upset because he just went and he punched somebody who just come out of the dentist's, and he messed with this guy's dental work that had just happened. And then he's being charged with aggravated assault because it's caused, sort of a disfiguring injury that he's got. And he's like, that's not fair. And I'm like, you chose to punch him without checking the situation of his teeth. That's on you.
Actually, I have another book promotional opportunity here that we stumbled into. And so I don't know. I'm on book promotion.
Is this your children's book? I was told I should ask you about that one.
Oh, yeah. Well, this is actually Death Penalty, Ideas and Answers in Law has a chapter on battery, and battery by slight touching, which can turn into felony battery. It takes a slight touch. So that's actually, I think, my favorite of all the chapters in this book. That's the one I'm favorite. Yeah. The children's book. So my next book I'm working on is a children's book, and it's called Brucey the One-Eyed Wonder Dog. And it is a book about, and everybody and people that know me, know I put my faith on my sleeve, right? I'm a Catholic and I'm a convert. I'm a recent convert, I should say, in the last 12, 15 years. And one of the things, I used to be a lot more agnostic, maybe marginally Protestant, right? And, one of the things that was a turnoff for me in Christianity was that people, was the fairy tale aspect that we sell children towards the faith. And, it's like, look, Jesus is your friend and he brings the lions and everything, right? It's like, and then people like, it gets lumped in with Santa and the Easter Bunny, and it loses meaning and loses the value, right? Yeah. Whereas we have to access our faith as an adult with adult eyes and recognize to strip out that fairy tale element. And so many times when I see children's books, they're selling fairy tales and they are not selling the morality. So I'm trying to create books in the children's books that have the Christian message without the hit you over the head, Jesus is your friend things, right? So in that vein, Brucey the One-Eyed Wonder Dog is about a true story about our one-eyed wonder dog named Brucey. who we rescued from the pound and who only had one eye. And the story is about living with disabilities, about having one eye, and the serenity prayer, which is about those things that we control and those things we're outside of control, and the wisdom to know the difference, right? And
Yeah.
about finding our purpose in life. And even though we have a disability in life, and in this case, he doesn't have an eye, that doesn't mean that your life has no value. Your life has value as a person, and we all have. I talked to a person on my Rumble channel recently who was paralyzed from the waist down, the hidden hand, and about how, but his life still has meaning. Everybody has faults, everybody has, weaknesses, and nobody is perfect. But that doesn't mean your life isn't valuable and that you don't have some calling that you need to find. And that's kind of what Brucey's about, is about us rescuing him and him feeling bad about not having an eye, and that who would want a dog with one eye, and that he's adopted by this family, and he finds that he has love to give, and that he listens to the serenity prayer, and he's happy with his life because he's found his purpose. So that's Brucey, the one-eyed wonder dog. I'm working on it. You can support that if you go to stevegosney.com and you click on the friends page. You'll see a picture of Brucey. I've hired an artist and we're rendering. The story is written. I'm just getting a great artist to put him together, and he's really cute, and I want to bring him to life. And so I promised people that I'm going to get it done by Thanksgiving. But that's my Brucey the One-Eyed Wonder Dog. I have another children's story that will come after that called My Difficult Dog, that's about my current dog.
But I mean, I am not a religious person, but I have tremendous respect for people who do religion right, and I guess that's by my standards. But
right, I understand.
And
some of my closest friends are atheists, and in fact, I would say that oftentimes I find, I would say I'd say marginally agnostic. Didn't really care about religion, didn't really care about faith until I confronted some things that gave me some humility. God blessed me with the humility, right? And I think faith grows out of humility and gratitude and truth. And in fact, I had my godson who I was having a crisis of faith, and he's in middle school, and his family's got a lot of faith, and he doesn't. And I said, well, the first thing you need to do is you need to ground yourself in truth, because you cannot build faith on a foundation of sand. So you have to be honest with yourself. And a lot of my friends who are agnostics and atheists have real trouble having faith because ultimately they're honest with themselves. And I don't want to I'm not going to push you into it. I have my own journey of faith, and you have your journey of faith. You have faith. You just have placed it somewhere, and you need to locate it. In fact, a lot of what I'm talking about here is in Prepare. Prepare is, like I said, my personal book. This talks a lot about my journey of faith and about building your faith and discovering where you have placed that faith and making sure that that place that you have put it is worthy of the vessel that you've poured into it.
I sort of come to things with a kind of the opposite of the Pascal's wager. Pascal's wager is believe in God because otherwise God will threaten you.
Right. And, well, that's the fear-based method, right?
But my take is kind of the opposite. It's be a good person whether or not a God exists, because hopefully any God worth worshiping will recognize that. And if not, what's it cost you? Oh, you had to be a good person. Just do your best at, just do your best at that.
And part of this is something like always do your best. And I think my faith calls me to do my best in all things. And I work people like, well, how do you write all these books and do all these things? It's because you praise God by doing your best in all things. And I also recognize that I will always fail at that, but that you strive for that goal. You strive towards that goal. And by doing that, you will make the world a better place by building on a foundation of truth and building up. And so I don't think we disagree. We don't disagree on the direction. Your faith you are placing in that direction agrees with my faith. You just have absented the God figure within that, right?
Yeah, it's just I can't do it. I just can't. it just doesn't work for me. I don't see that out there. But at the same time, it's like, I can see that there's a lot of value in certain religious teachings, and I borrow from. Like I had a discussion with Joe talking about some religious stuff, and he's like, "Hey, there's a book that's kind of covers this," and I went and bought an English translation of like a Jewish text, because I'm like, I kind of feel like we should be taking the best from various things, and like my thoughts on the death penalty are partially, inspired by like reading the Bible and like the parable of the tares, right? And people fall over themselves to say, "Oh, that's not about." It's like it seems pretty clear on that one, like what was being talked about.
Well,
Unless you think
thank
Jesus
you for
is
bringing
giving
up my
farming
death
advice.
penalty book, because in death penalty book there is a portion on this about Christianity and the death penalty, and I've incorporated that. I try to incorporate faith in everything I do, and that includes. But that, for instance, and one of the things about weighing net positive or net negative is if faith has a lot of power for you, then that might be the decisive factor in your scale. But if Christianity has no value, then you can weight it very low. So the value of that, depending on the audience, I've listed it out as a reason to be against it, but it may not have any weight to you at all. You may have other reasons to be against it. So, these are all individual decisions, and we all are following an individual journey.
So, and Jill with Graceful Answers Ministries, you two should talk. She's got a fairly new YouTube channel, but she talks about sort of a lot of this kind of stuff. I should probably get through super chats and start wrapping things up, because
Man, this is so much fun. Thank you very much for having me on. It's been a blast.
Man, I've got tremendous respect for the work you do and the thoughtfulness you bring to everything, and the like your stuff. So I was like, I've got to have Steve on for a while.
It's an honor, and I'm doing it. I've kind of not been doing much on my channel. I've got posted a bunch of oral arguments for every Wednesday for the next 4 Wednesdays, because I'm doing a death penalty appeal right now, and it's kind of taken all my time. But it's fun because this is so much fun. It's so much more happy. People say, "Why am I happy?" Because I'm on here. This is great. When I go to work, it sucks. So it's fun this is enjoyable, and I don't really have to prepare that much. And so thank you for having me on your channel.
Oh, we'll make it happen again, because it's as I said,
read the conclusion. We read the conclusion.
We read the conclusion. Yep.
Yeah, we did that.
Yeah, Julia is saying we should read the conclusion. We did read the conclusion. It's in there. It's back there. So basically they said, listen, you can testify about some things that are fire and ballistics wise. You just can't testify that it's a unique match that is like nowhere else in the universe. So
right. Well, that's exactly it. They can testify as to general characteristics of firearms and whether the firearm is operable, but they cannot testify that is a match. The way that they should testify is this firearm is consistent with the fire in that projectile. That is sufficient. That is the extent of what they can say. This
bullet could have come from this gun.
Yes.
But it definitely did.
Exactly.
And I mean, I got no problem with that testimony.
No,
like that is entirely within the realm of a forensic scientist, is to say, I think it, based on my impression, it could have come from this gun. That I have, because there are people there going, like, what forensics do you accept? I'm like, I accept lots of forensics. I just don't, when they get into the weeds or outside of what they can do, that's where I get to be a problem. So, I'm also thinking I need to order the next 2 seasons of the Hot Ones.
of the hot what?
The Hot Ones. So those competition packs. Although maybe I should. Some of them are.
You're losing. I don't know, man. I can't handle it. I mean, I'm a lightweight on drinking. Even I love hot sauce, but man, that I can't do it. It kills me. I'm telling you. No,
I
you're in a different realm with that world.
I really enjoy. I mean, the thing is you just sort of slowly work up just by liking hot sauce, and that's just how that goes. The one of the funniest things, I did a hot wings challenge at a bar, and it was you have to get through 10 wings in I think it was 2 minutes. And they were like, "This is our hottest wings," and if you succeed, you would win free wings for a year. Of course, once you win that, then they're like, "But it's only on Thursdays and only with a beer, and you only can order one." I'm like, "That's not free wings for a year. That's like so many rules." But so I get this thing, and I'm going to town on it, and they're trying to make it a show. So they've got this guy with a microphone, and they put this microphone in my face, and they're like, how hot is it?" And I'm like, it's okay. I keep going, and they're like, "That is not what we expected to hear." I'm like, "Then make hotter wings." And I just keep going. They tasted awful, and the other thing is I actually got quite sick off of it. There were so many people doing the challenge that the wings were coming out pink. And so after I finished, like, you can't notice when you're doing it because you're under time pressure. You're eating. But afterwards, I looked down at the bones, and they're like bloody. And I was like, "Oh, this is going to hurt later." So I spent the next like several days sick because I'm sure I got salmonella from that.
No.
So
well,
that was
my son likes hot sauce, so maybe if I'll ask him if he wants to go toe to toe with you, but he's got too much common sense. My son is very level headed, so probably not. But
yeah, just go online and like put in hot ones challenge. They've got they've got a YouTube channel where they do it with various celebrities, and you will see a bunch of celebrities just wanting to die. A fair number of them tap out. So
go watch that hot noodle chicken thing with Brian Shaw and Robert Obrist. It's on Brian.
Now I gotta look that up.
It's really fun. It's the funniest video. I mean, it's one of the funniest videos I've ever seen because they're these huge guys. I mean, they're like, Brian Shaw is 6'8", 425 pounds. He's just huge, and they're torturing themselves with this hot noodle thing. It's just too funny. I don't know.
I'm gonna order some right now, because they don't look that bad.
They don't look that.
It's $15 for a package. They ship to my address. Yeah, I'll totally do that.
How can you not get it?
Oh, I will totally buy that, and then people can watch me die or not die on a video. Yeah, Rob went toe to toe with me, and Rob had a much worse day than I did on that.
Was that Rob Lawn Lumber Rob?
Yeah. On my birthday stream, we did the Hot Ones challenge, and if you ever feel inclined to go back and watch it just for giggles, Kurt is on. He's not doing the Hot Ones challenge. Kurt has more sense, but Kurt is asking Rob law questions, so he's like dying of heat, and Kurt's like, "So, what is the rule against perpetuities?"
Is that how many was that? Was that a
he was asking about that would have been January. So yeah, it was
you
fun.
Are sick.
All right, I better go through some super chats and memberships and so forth, and wrap things up because yeah, it's getting late and I should eat.
Too much fun though, but yes, we can wrap it up. But thanks for the opportunity. Thank you for your beautiful chat, for sometimes abusing me, but most of the time being very nice and welcoming. So thank you, and thanks. Go to SteveGosney.com and buy some books and help me out.
And even when my chat disagrees, they tend to do so in a respectful way.
They're very
really
nice.
like
You've got a good chat. I'm impressed. Oh yeah, look, you've got somebody just hammered you with a big super chat. So
oh wow. So Jaragon, Jordan Peterson inspired me to take my extremely religious right-wing views and tame them. I couldn't believe how liberal and agnostic I discovered myself becoming while respecting where I came from.
That's
I have
interesting because he took me a little bit. Well, I don't know. I don't know. He's had some impact on me. I mean, the guy, I quote him some in my book, and I haven't followed him recently. Most of it's from the old lectures because I love Carl Jung's work.
the
And
problem is sometimes Peterson is really insightful. Sometimes he's just noodle doodle crazy, and it's like,
but you take the value from somebody that gives you
yeah,
wisdom. And the thing about there's a number of things that he taught me, and I repeat them some in Prepare. And I disagree on a lot of things, but it doesn't mean that he doesn't have a lot of wisdom to share, especially in the Jungian part. And I think humility and gratitude are really key. Those two values, because when I wrote Prepare, I actually had to write out my faith, and that was very hard. I mean, most people haven't had that exercise. And
I think it's a good. I actually at one point sort of started like writing, and I don't have it to like share with anybody, but I wrote out like my moral, like what are my moral imperatives,
right.
and it's tough. You got to actually start sitting and think about it.
Tough. And in fact, as even writing Prepare, I start out because I'm a big believer in individual freedom. And that's a core value, but I value truth even higher. And that came clear by writing Prepare and having to be truthful with my analysis. And it ended up because, I tend to be on the conservative side. And the question that was posed to me by my atheist liberal friend was what my position was on originalism, which as a conservative, originalism is a big part of how we look at things. And by wrestling with that question, I came up with the fact that originalism is important, but it is not sufficient. And a pure originalist view of the Constitution is a recipe for tyranny. And that's the beginning of Prepare. And that was sort of the beginning of the evolution of that. So we all have to, we don't know everything. Open the mind and be humble.
And Susan, I will get to every super chat before we wrap up here. It will happen. The other thing I found about writing out your moral thoughts is that it can be difficult because you'll sit there and you'll be like, I'm not like, this is a principle I believe in, but it's not a principle I'm doing very well at. And that can be a tough thing to stare at when you're looking at the page going, this is something I believe in, and crap. It's like, oh.
Well, being humble means taking a stand on those things, but being, it's a conscious humility. I actually I don't know if people know this, but I talked with Clarence Thomas a couple times, and he expressed this in a way that I really take to heart. And it's not a false humility. It's not of like, because I know what I know, and I know when I know it, right? But it's also a conscious humility. It's something that you work at, that you decide to be because you may be wrong. And going at things and recognizing that this is what I know, this is what I believe, knowing yourself, but then recognizing that we're all fallen humans, and that when we're confronted with something that disagrees, to not attack or belittle or to criticize, but instead listen with open ears, with the understanding that I consciously may be wrong about my beliefs, even though I'm very strongly opinionated. So it's a conscious decision. It's not a throwaway value.
And anybody who thinks that they have always been right on every sort of moral principle and so forth is
sadly mistaken.
Yeah, exactly. All right, I got to get to super chats. I think my wife is starving to death as well, so I'm going to see what we can do here about getting through these. You're welcome to stick around or depart as you wish.
No, I'll stick around. I'm having so much fun. This is playtime for me. This takes me away from my regular duties.
So Nisa Howard is saying, check out the book Punishment Without Crime. And Emma Zay gifted 5 memberships, much appreciated. Koru gifted 1 membership, much appreciated. Let's see, scrolling up here, we've got Rideman YYC. Cartridges are made to a set of plus minus tolerances, as are chambers, as are rifling. Tolerance stacking makes even measured features uninformative. Yep. So that's just as you get these different tolerances adding up, like plus minus 1 on this, plus minus 1 on this, gets you to plus minus 2. Mark, isn't this a black swan problem? How can you ever say there's no other tool in the world that makes this mark if you haven't tested all of them? That's exactly the problem.
Exactly. Perfect. That's a major criticism of what we're talking about. And the decision talks about that.
You don't know how many swans there are. It
Right.
could be 1, it could be thousands, right? And it could be literally, could be that the gun store sent or that this, like a lot of Glocks all got sent to the same town that are sequentially made. You just don't know. Tom Horton, thank you very much for the $10 support. It's much appreciated. The Winged Hedgehog, thank you, y'all. You make it better. Winged Hedgehog was saying they were having a rough night, so I'm glad that makes it better. Nicholas Trial Watch, Wisconsin versus Allen Brown, 32-second opening statement. Fell asleep during state's opening statement. Yeah, sometimes there are really bad lawyers out there.
Well, and I really work hard to keep things interesting whenever I'm speaking at a jury. And this is a big flaw of a lot of these prosecutors we're seeing, is they love to hear, just goes on and bores the jury to death.
Oh, it's it happens. And jury work is partially being entertaining. Brian Alleman saying the problem is inconclusive results that the prosecution treats as positive matching result when they say a gun can't be ruled out. Yep. And in studies, non-matching pairs are more likely to be ruled inconclusive than eliminated. Yep. Both of those things bias towards convictions. Mark, thank you very much. There's so much junk science in court. Look into arson investigation. Texas executed Cameron Todd Willingham in 2004 for an arson that wasn't an arson. A lot of arson stuff has been shown to be just completely made up. Like when they talk about pour marks, are you sure? Because you can get those same marks from all sorts of things, like a couch melting kind of thing. Rhineman YYC, NC Sammy standards for centerfire pistol ammunition is worth a look if you want to learn about the tolerances to which this stuff is made. Yep. And we've got, this was not a super chat, but I started because Campsite Z was saying, can you please inform Mr. Steve Gosney about how Under Armour is an anti-hunting brand after dropping the legal spear hunting pros in Alberta prior to the stock drop? This was a bit of a controversy because there was a hunter who went out spear hunting, and as a result of that, they banned spear hunting in Alberta. But Under Armour, I think, didn't want to be too near that controversy, so they dropped sponsorship on all that.
See, I don't know. I just got, the shirt was bought for me. I just wear it. It's comfy. It's black and it looks good on thing. And I put a coat over it to make myself look like a lawyer for a moment. So
I don't think it's a harsh criticism.
I try to avoid. I really do try to avoid. With voting with I vote with my dollars on things that I buy. So I'm appreciative that this person is bringing me at that attention, but I was unaware of this point.
Yeah, I figured that. I didn't figure that this was like a harsh criticism. It's just like, hey, this is something you might want to look into. It's up to you, kind of thing. Equality is saying, to be 100% honest, I used to think defense lawyers were doing it for money, etc. You guys changed my mind completely. Thank you for all you do. I mean, defense lawyers get paid, but my dream is to get my money off YouTube and then just run a pro bono firm. That's what I want to do. I don't know if I'll ever get there, but if I do, that would be the dream. It's just purely just YouTube based, and then just do files for nothing, because there's so many people who can't afford counsel.
Right.
Susan Davidson, love this as it's Ian's passion. Good debating. We just love talking about this kind of stuff. It's
Yeah, it's really been a blast, and Susan has been in the chat all night, and she's great. I really like her. I don't know, I
Oh,
don't know
absolutely.
Susan. I think this is my first time dialoguing with her, but we're having fun in the chats.
And I see Tom Horton, don't kill the lily sounds like good advice for criminal prosecution, not just civil, and something prosecutors should heed. Absolutely.
Absolutely.
I watch way too many lawyers and witnesses and whatever just get themselves into the weeds because they want to be too good. Even like defense lawyers who are talking about their clients is like, my client is an angel. And it's like, nobody in the courtroom believes that your client with like the neck tattoo that says like murder is a great person. Don't try to swing that that your client is the best person ever. Just swing it that your client didn't do the crime, right? That's
But it's interesting how the prosecutors also, they put the little saint halo on their victims. We
oh yeah.
saw this in that Miami trial with the NFL player recently, where the prosecutor lost so much credibility by turning their little thug home attackers into these like they're little angels, and he's a hero because he threw himself in the way of the bullet as they were fleeing from the home invasion, right?
Oh yeah.
It's ridiculous. So that does play on both sides, right?
Well, and there's always this debate that happens in self-defense cases. They're like, is it better if this person dies? And I usually say no. The reason, and everyone's like, but then they're there to testify against your client. And I'm like, good. I usually want that person testifying against my client. I mean, first of all, it means that my client's not looking at a murder bit. He's looking at something less than murder, which is great. Even attempted murder is way less than murder. But the other thing is that when they're dead, they're presented as saints.
Right.
All their family members will be, oh, he was such a great person. Like he fed the homeless. And then when he's actually alive, you find out that he never fed the homeless. He threw a hamburger at a homeless guy once because he thought it would be funny. Right. And it's,
Well, these
when
kids,
the
I mean,
guy's actually,
I don't know how much you followed that NFL trial. The guy, he got a not guilty, and they were looking to, I don't know if it was a death penalty case. It might have been, but this guy, he shot his AR like 37 times at a fleeing car.
yeah.
Yeah. And it was ridiculous. The prosecutors going in there trying to make out these thugs that were attacking this guy's home, him and his brother. The parents were really, I mean, it was clear who the good guys and the bad guys were. It was a close case on a self-defense charge. It was a very difficult self-defense case. But the prosecutor blew it. I even said at the time that I think that these prosecutors, it was a winnable case, but they blew it.
The little bit I saw, I was like, this looks like it's winnable, but the prosecution blows it by trying to make their guys too good. Whereas if they just said, hey, he shot too many times at a fleeing vehicle, they probably could have gotten a conviction on that, and just say, hey, but yeah, if you're calling him a hero, it's
yeah, the guy was not a hero. They were going there to attack and beat up these guys at their home, in response to this crazy married woman who was dating and was calling them out. It was 4-on-2. It was not, these guys were not good guys. Now,
well,
they didn't deserve to die, but but for the prosecutor to say that, I think
they lose credibility with the jury. The jury at that point doesn't believe the prosecution.
Right.
And if they don't believe the prosecution, the case is over.
And we actually, during one of the wrap-ups of that case, we actually had a relative of one of the jurors in my chat. Okay.
Oh.
and they were saying that it was a very hard decision for that jury.
I can imagine.
And it was. I mean, that was not an easy case, but they made the right decision, I think. But also, like I said, the prosecutor blew it, and throwing out your credibility may be the tipping point where you lose that case.
Yep, absolutely.
Never do that.
Yeah, if the jury doesn't believe you, you're hooped. Random Rambler was saying the problem people have is throwing out a guilty verdict when it's clear he's guilty or something people don't think is an actual problem. This is why defense lawyers often are looking at like broader principles. Like in this case, the broader principle is this ballistic matching is bullshit. And this guy will get a new trial, and he will probably get convicted at his new trial. That I think is likely, but that doesn't mean that it's happened, like that it should happen on this bad evidence. Like, convict him on good evidence. That's, or don't. You know, Connie Fell is saying, are they even accounting for the basic scientific concept that correlation doesn't equal causation? They're not accounting for a whole lot of basic concepts, I'm afraid. MLS Law Show, welcome to the membership. And was asking for the citation. I have since sent him a link to the case, so he should have that. Susan Davidson, happy anniversary at Valhalla Awaits. Awesome. Jaragon, the test says he's guilty and we say so. You don't get any more inexpensive than that. Panel, what percentage of people do you think get convicted on junk science? There's a lot of junk science out there. There's people who've been convicted on digestion study, like science, saying this person had to have been killed at this time because of their digestion rate. And the problem with the digestion rate stuff is you digest at different rates based on, like, you know, if you're stressed, if you have adrenaline, you will actually slow down your digestion because your body's like, I need to do things like running and fighting and not working on this steak. So it can throw things right off.
Can I just plug, if you're interested in the forensics, and that's kind of the forensics, check out this PCAST report.
Oh, absolutely.
This is the document. It's cited to in the case, September 2016, President Council of Advisors on Science and Technology. And this goes through all these different sciences, forensic sciences, and kind of gives you a good understanding of the problems and the strengths of different sciences that they're presenting.
Yeah, and I can say that there's unfortunately a lot of bad science and that creeps in. We have witnesses here who testify as expert witnesses on whether or not drugs are for the purpose of trafficking. And like, hey, we found drugs and a scale and whatever else, so this means this guy's trafficking. And like, the science on that is just non-existent because it's just their feelings, right? So yeah, it's nuts. We read through that one. Eric was saying, if it's not supported by science, then I agree completely, it's bunk science, but ballistics, among many other specializations in Ontario, are evidence-based. You know what? If you are a ballistic, like if you're a forensic scientist out of Ontario or anywhere else, hit me up. We'll set you up with a challenge. You can prove you got the evidence. You can prove you got the science. And there's some money in it for you as well if you're successful. So I think right now we're up to $2,500 because MLS pledged $500. So Greenwood JW, I only wish I had a committed defender. My PD in Baltimore court didn't even call the witness I identified, just look for a minimum sentence.
Yeah, and this is and we had Natalie on here, who's clearly a good public defender, and I've interviewed several of my people, and not everybody is equal, and we all have our weaknesses and strengths, right? So just like humility goes in office, I know where my strengths are, and I know where my weaknesses are. I know I'm not a good negotiator, right? So I am not a trial guy. I mean, I'm board certified criminal trial law. I've done over 80 trials, but I don't think I'm best placed in the trial division because I parachute in on the cases that I want to try, right? But as far as the management of the schmoozing of the prosecutors, I'm the wrong guy for that, and I recognize that. That's why I do appeals. So,
I mean, the other thing is, there's just bad lawyers out there. There's people who
there's good and bad cops, good and bad lawyers, defense attorneys, prosecutors. Yes, we're all human beings and we fail in many ways. It's a human system.
And I see Mandy Kravitz is saying, I'm not sure my super chat went through. I don't see it in my starred super chats. So it might have been missed. I am sorry if that's the case. Secret Labs customer support. I'm looking into establishing myself as an expert in forensic, not sitting wrong science. That's a running joke about my this chair is a Secret Labs chair.
Oh, okay.
It's falling apart and they're not good. And every time I send them something saying that there's a problem, they're like, "Oh, you're sitting wrong." I'm like, "How am I supposed to sit? Like, sitting is not complicated, dudes. It's just your stuff falls apart because it's crap." Um, I've never had this problem with any other brand of chair, but Diana B is saying, "But Ian, is that lawful law?" Daryl Brooks is classic. With your birds, I get the point about wanting to give only food, but those drugs and alcohol are probably the only comfort allowing them to get through the day. Yeah, I kind of feel that when you've got a guy who's got massive like addiction issues and is going to be going through withdrawal if he doesn't get the drugs, I get why they want the money for the drugs, right? Penny Riordan, thank you for the membership there. Dayslav Act, mandatory carry, keep fighting. Well, thank you very much. Thank you for the $5. Susan Davidson, Ian, swoop every book pitch. Peggy Riordan, what's the shelf life? I'm told it's shelf stable. So it should be able to sit on a shelf for, the standard for shelf stable is at least 6 months, just sitting on a shelf. So that would be what I've been told. Jeff Moser, I did the Satan's Toe once, 9mm Scoville units.
Yeah.
I have right here, I've got the little nitro. World's hottest gummy bear.
Oh my goodness.
It's got a warning.
You love that, man. You really are a.
Yep.
I didn't know this. This is the factoid I'd learned about Ian Runkle tonight.
Well, it says that this one is 9 million Scovilles, but I've also heard that it tastes awful because it's made with extracts, and extracts usually taste bad. So I'm going to have to try it at some point, but not right now on an empty stomach. That would wreck me. Cat in Virginia, testosterone poisoning.
Yeah, that's what we were talking about, like men and their egos.
And it can be lethal.
It can be a lot of that. Yeah.
If you want to break from Nicholas Starrow's trial watch, if you want to break bones in stupid ways, become a goalkeeper, handball goalie for far too many years. Yep. Equality. I remember watching Daryl Brooks' trial and thinking the victims and victims' families do religion's right. My humble opinion. I have seen. I actually saw. Like, we get victim impact statements here. In a lot of states, they get the same thing.
Yep.
And the what is it? So afterwards, the victim impact statement basically said, for our religion, we actually think this guy should be forgiven, and we don't want a stiff sentence.
Well, but see, there's a difference. And
the prosecutor was so pissed.
I beg to differ with this. It's a theological point. But forgiveness is a gift that you give yourself. Okay. And it's sort of an odd thing. Like, I have daddy issues, right? I was raised by a single mother and had problems with my dad my whole life, and very difficult, dad issues, right? And I had to really learn to forgive, to kind of to move forward, to not dwell on woe is me, poor little me, I've got daddy issues, right? You have to forgive, to move on, to live your life, to be free. And it's not one time, it's a constant state. Sometimes I have to go back and re-forgive because, and what it does is it lets go. In fact, I came into my faith through forgiveness. It's a gift that I needed from God that I was not able to accomplish on my own. It was greater than me. The hatred in my heart was something I needed to get rid of in order to do the good things for my wife and my son and my family that I was not able to do. I was getting dragged down into the black hole because I couldn't let go of hatred. I couldn't forgive. So forgiveness is something that you need for yourself. Vengeance is a sword that you wield. Is a sword that you wield by the blade. You really have to be careful with that vengeful spirit. And it is not Christian. And it's something that it's a great call. It's almost an impossible call, but it is the call. And so I would say that a good example of forgiveness is Dylan Roof, the shooter in that shot I think it was 9 people in the Black Church, the AME Church in South Carolina, and every one of those people came up there and forgave. There's a movie on this called Emmanuel where they forgave the shooter. Now he's still got the death penalty, all right, but the fact is that they were Christian. They were an example of Christian forgiveness, so that they wouldn't be drowned in hatred.
Yeah. Well, I mean, you can have, like, there's two sides to it, and I think that there's definitely value in forgiving, just for your own benefit, but also forgiveness, like, can also be a gift towards the other person as well.
It can be, but I'm just saying that it's also for you. It's a two-way street.
Yeah. Well, and the other thing is, like, it can be like, I forgive you. There's a guy who, he stole some stuff from me, and he's like, and I'm like, I forgive you. And he's like, okay, cool. And I'm like, but that doesn't mean we're going to have anything to do with each other.
Right. Exactly. It doesn't mean you forget. This is a very important point that you're making. The forgiveness allows you to lose the hate in your heart that will destroy you and eat at you. But it doesn't mean you forget. Like what was done to me by the prosecutor's office. I remember, but I don't, but I've forgiven it. I don't hate.
And every lawyer keeps track of which other lawyers they can trust and which other lawyers they can't.
Absolutely.
And, so if you're going into law, make sure that you act honorably, because everybody will hear if you don't.
Oh, that is so right. That is so right. Oh, thanks, Susan Davidson. She's my new buddy, man. I picked her up in your chat, and she and I have been going back and forth, and I like you too. You're a good chatter.
That's great.
Huh?
That's fantastic. And L. Fliggins, thank you, just because I value your perspective. Mandy, I see your super chat. I can't pull it up on the stream, and I can't really respond to it because YouTube will nuke my channel over that one.
Now I want to know what it is.
We'll talk.
Oh, okay.
I can tell
you
off screen.
I got you. I see it. All right.
It's YouTube has strict policies. They will go to town on the channel.
That's why most of my stuff is over on Rumble.
Yeah. I mean, they've got their policies. It is what it is. And I see Lacey Petit has a member chat saying, great stream, brilliant brains. Y'all are amazing. Thank you so much. We'll just, I think at this point we'll wrap things up. I will roll the outro credits here, or the outro video, and see everybody next time. Let me just find that outro clip here. Here we go.